Item number 1.
My apologies, my lord. My lord, before I enter into the facts of the case, this is the 5th occasion, my lord, this matter has been listed for this same occasion. And the government is, my lord, keeping on taking time for instruction. In the name of instruction, five months has already elapsed.
So,
And I am sure they might appear today with the instruction.
Lordship, instruction is there, Lordship. So per NOC from the police department is concerned, that is not there, Lordship. Earlier, there was a litigations pertaining to the NIT for constructions of this road, Lordship. There one Navam Tolon, Lordship. He was a petitioner challenging the tender process, Lordship, for this particular road. And that was Lordship dismissed by this court, and Lordship was the Lordship one who passed this order.
so I cannot take up.
No, Lordship, just I'm appraising this honorable court, Lordship. Apart from that, Lordship, I have placed the communication made by the police department to the Union of India seeking approval for the Lordship NOC.
Construction is over.
Construction is almost done, Lordship.
How you before obtaining the NOC? How you construct the
Lordship,
violation of the law?
that is their Lordship. Therefore,
Clearance has to be obtained first.
that is correct, Lordship. That is correct, Lordship.
It's almost completed.
It's almost completed, and the police department has already directed them to stop the work, further work, Lordship, until this NOC is obtained, Lordship. And this
How the state can be so casual?
Lordship, that part is
See, law is there. You have to obtain clearance
Lordship.
before you do something on a reserve forest. Are you admitting it's a reserve forest?
Here, Lordship, what it says. Kindly see the Lordship recommendation, Lordship.
Where it is?
I have
We're not.
one second.
Initially, we thought it's not maintainable,
Lordship.
but something is there.
Lordship, only the issue of NOC only.
At least aberration is there.
Aberration is
Prima facie violation of the
the last.
Forest Conservation Act is there.
Last page, kindly see the recommendations of the state government, Lordship. The last page, Lordship.
Violation.
The nodal officer has recommended the proposal. The proposed diversion site does not form a part of National Park, Sanctuary, Biosphere Reserve, a sample plot, preservation plot, ecologically fragile zone. The diversion is not likely to affect habitat of any endemic threatened species of fauna or flora. No effect on any stream, sea, water body, or forest ecosystem and biodiversity is anticipated as on date. The project is not likely to adversely affect timber, fuel or wood, MFP supply to rural message, Lordship. These are the observations made by the state government while recommending for approval of NOC from central government, Lordship. Even then, the fact remains that, Lordship, NOC is supposed to be taken from the central government as per the Forest Conservation Act, Lordship. And from the police department, we have already directed the
diversion site does not form a part of national sanctuary biodiversity reservations. Ecological preservation. The diversion is not likely to affect habitat of any endemic threatened species, for no effect on any stream, sea, water body, forest ecosystem. Is anticipated as on that.
Lordship.
Project is not likely to adversely affect timber. Well, this is not the decision. I mean, this is a recommendation.
This is a recommendation, Lordship. Just factual how the flora and fauna is likely to be affected, Lordship. That part
They
just
said it may not affect. They are just anticipating.
correct.
It would not affect.
Lordship.
It may not affect.
May not affect, Lordship.
And that too, it's the recommendation of the state government.
Recommendation by state government. Approval is
Not the expert or something. You file a detailed affidavit.
Close.
Consider.
Lordship.
Heard Mr. C. Modi, learned counsel for the. That would be better.
That will be better. Right. That is fine.
Looking there.
That is fine.
Obviously, they will say once they will study, we want to be obviously they will stay. But it may not.
Mm.
They don't do it, they don't. They are obligated to all the work. How do you say this is specific to the video? How do you do that?
That is fine.
And Mr. Estapin Nanit, Senior Government Advocate for the state respondents. Although Mr. Estapin Nanit, Senior Government Advocate, furnished a copy of the letter sent to the Deputy Director General of Forest within Bracket Central for seeking diversion of 28.28 hectares forest land for construction of double length road from road between Donipolo Airport, Itanor and Railway Station Naharlagan via Sonajuli and Rupang in the district of Papumpare, Arunachal Pradesh. Same does not response, same indicates incomplete response to the issue raised in this petition. Mr. Accordingly, we grant 3 weeks time to file detailed affidavit in the matter.
My lord. In the meantime, my lord, I am praying for entry, my lord, till the my lord, pendency.
Let us see.
My lord.
Let us see. It's a public project, and hopefully they will grant the clearance.
Yeah.
It's public project. Everyone will be benefited from it. Railway, airport, including you and us.
All right.
May I, Your Lordship?
Yes.
Lordship, I beg to mention item number 10. Here, we need to file our, we have received a parawise reply, so we need some more time for filing our counter affidavit.
Item 10.
Yes, Your Lordship.
Yes, my lord, this item is supposed to be listed in the order. So it is listed in admission, but our government respondent yet to file affidavit, my lord.
On on the prayer of MSP Pangulan State Council, let this matter be listed after 3 weeks so as to enable her to file affidavit in opposition on behalf of the state. Mr. N. Rama,
Yes.
counsel for the petitioner, is present.
Yes.
Obliged,
Much.
Your Lordship.
Lordship, I would like to mention item number 30, Your Lordship.
30.
Lordship, may I kindly fix this matter on 3rd of March, Your Lordship.
30.
Yes, Lordship, I've taken the consent, Lordship. 3rd March.
Why? There's nothing will allow the writ petition. Gabura has decided something. Judicial side. How can there be an FIR? And how can you register an FIR? Will dispose of. Where is there?
I've taken the consent from the petitioner, Your
Doesn't
Lordship.
matter.
That one.
It's up to the court.
Lordship.
Tomorrow.
Tomorrow.
There's nothing.
Lordship.
We'll quash the FIR. AJ Gabura wrongly, rightly, he has decided something. Just unnecessarily. If you are agreed, you file an appeal.
Lordship.
The two, after the coming into force of the Civil Courts Act, they are the first court of first instance.
Lordship.
Tomorrow, when? We'll hear the PP also. Where is the PP? You inform the PP, we'll take it up tomorrow.
Lordship. Apply.
On the prayer of learned counsel for the parties, this matter on 19/02/2020.
May I, Lordship?
Yes.
I beg to mention item number 16 on the behalf of Til
Hmm.
in this case. He have some personal issue. So it
Item,
cannot be
item
number 16, Lordship.
16,
16.
contempt matter.
Yes.
Yes.
So kindly the matter may be adjourned for today, Lordship.
Then 16 and 17.
16.
No. Huh?
Also, this contempt is filed by me. It's there.
Take a taka wala. Sorry, Lordship, got to.
Mentioning the wrong item.
Hmm.
Yours is criminal petition.
Then next.
Lordship, I beg to mention item number 5, Your Lordship.
Hmm.
In this matter, I need some time for filing one additional affidavit, Your Lordship. I'm representing respondent number 1 and 2.
Time was given, president with the context.
Item 5.
Yes, Your Lordship.
State has filed this.
And Duncan is also there.
Yes, Your Lordship.
Respondent 3 Lordship.
So no objection.
No.
You are for?
I'm for respondent number 1 and 2, Facilitation Council, Your Lordship.
You have filed.
I have filed my affidavit in opposition, Lordship. Lately, I have come across one office memorandum. I need to bring it on record by filing in the form of affidavit,
Office
Your
member
Lordship.
in connection with, what does it say?
Lordship,
What does it say?
it says, Your Lordship, that the works contract, MSEFC has the jurisdictions to adjudicate, even if it's works contract, Your Lordship. In that regard, the clarification has been issued by in the
By the
in the
minister.
form of yes, Your Lordship, in the form of
Ministry.
circular. Yes, Your Lordship, Ministry of MSEFC, Your
In fact,
Lordship.
I would not have taken that ground while arguing. I
Lordship,
would not have taken that ground. I would have taken another ground. There.
one of the challenges that that is one of the challenges.
But I would not have urged on that
I
ground.
think that is the one of the.
That was
basic
one of the
challenge,
ground,
Lordship.
but I would not have urged that ground.
Hmm.
I would have urged other grounds, man.
They have taken that stain, Your Lordship.
Yes.
Hmm.
Therefore,
If-
I need to file.
What are the other grounds?
Other ground is that the provision of section 18 of the MSME Act was totally not followed, my lord.
What is 18?
Section 18 says that the conciliation has to be done as per the provisions of the Arbitration and Conciliation Act. The section 675 to 81 has to be followed.
No, Lordship, as per the new amendment 2022, it has to be done in terms of the Mediation Act, not in terms of the Arbitration and Conciliation Act. There-
What?
That also, then also, that also.
Learned additional AG in the. I mean, appears to be in the sticky wicket. Anyway, if you have no objection,
Yes. Madam.
otherwise that can be placed or produced also. Anyway, on the prayer of MS and Anju Learned Council for the respondent number 1,
1 and 2, Your Lordship.
1 and 2, and the prayer not been objected to by Learned Council for the petitioner, Mr. N. Ratan, Learned Additional AG, and MS N. Dungan, Learned Council for respondent number 3.
Yes, Lord.
Let this matter be listed after 3 weeks,
Yes, my lord.
so as to enable her to bring on record the circular issued by the central government,
Ministry.
Ministry of what?
Lordship,
You just give the Ministry of so and so, whereby it is
MSME.
clarified
Ministry of MSE.
that clarified about the works contract. Works contract,
Lordship.
okay. List after 3 weeks.
My lord, the interim order may continue.
interim order passed earlier shall continue.
Problem.
My lordship, your lordship, I beg to mention item number 19,
Hmm.
your lordship, 190.
Hmm.
Your lordship, I've just gone through the records, your honor. Your lordship, the notice is still not completed. So I'm,
Mr. So-and-so, Land Counsel for the petitioner, award service notice list after 4 weeks.
yes,
Ah.
obliged. Your lordship.
Hmm.
Lordship, I'd like to mention one WPC 251/2025 to be taken, Lordship, today.
Why?
Lordship's circumstances is we have filed the inter senior list.
It's a new matter.
Lordship, service matter. This is
New matter.
Lordship. This the on
Pending matter.
pending matter, Lordship.
Next week, Monday.
Lordship, that if it is
What
not
was
taken,
supposed to be listed?
Lordship, that only just I come to know that subsequent order has been passed, Lordship.
So you challenge that. You bring on record.
Lordship,
First you do your job, then we'll consider.
Lordship, we have filed the IA, Lordship, today.
Yeah.
Yeah, Lordship.
Monday.
Obliged, Lordship.
Or tomorrow.
DPC is going to be seated today, Lordship.
But we cannot. Cannot do anything. We cannot stall the DPC.
Lordship, in the main writ petition, two junior has been that placed above my Lordship seniority list, Lordship. This is the fact.
You have challenged the seniority list.
Yes, Lordship.
Can't help it. Tomorrow,
Lordship.
we'll see. Or it doesn't make any difference.
Lordship.
If it doesn't make any difference, next week. Next week.
Lordship, may tomorrow, Lordship. Obliged.
Item number 1.
Before this matter is taken up, I am for the caveator in this case, and there is a matter, item number 7. There is a contempt which is connected. So just I am informing the court. 7, there is a contempt which has been filed by us, and second, I am a caveator in this case.
Lordship, NSPC will be represented by Mr. S.B. Raju through RBC.
So the contempt arises out of the award. This award.
Yes, correct.
01/08/2025.
Yes, correct, my lord. 1/8/2025, only for the purpose, my lord, with great respect, only for the purpose of circumventing this order, this petition has been filed. And this subject matter has already been decided by earlier round of litigation, my lord. Earlier round of litigation, it is a consent of both the parties, my lord.
So you have filed a writ petition.
I have
for
not filed,
payment of compensation.
my
In
lord.
terms of the award dated 01/08/2025.
Which one, sir? I have not, my lord, the counsel, my friend Mr. Raju appears for NSPC.
No, I'm asking whether that contempt is arises out.
Arising, yes, correct. Your lordship is absolutely
Award
right.
dated
Yes.
01/08/2025.
Yes, your lordship, there was an order passed by the court on 10th of February 2025. After hearing the parties, NSPC as well as us, because there were two writ petitions which was filed, one by NSPC. In 2018, there was a notification which was issued by the state government, 30/8/2018, for acquisition of land, my lord. And according to that, my lord, NSPC, the award was assessed, and ultimately the amount of 42 crores was awarded.
There is item.
Item number 7, my lord. Contempt.
May I only submit this? I may be heard for 5 minutes. I'll show why the contempt is not maintainable, my lords. May I only show for 5 minutes, if my lord permits me?
My lord, it is my contempt. Let me.
Just wait.
Yes.
I'm trying to understand.
Yes.
Definitely will hear you.
Yes.
Okay, this can I take up this matter? Item 7. There's no issue.
No issue.
We have no objection, my lord. We have no objection.
Did I not appear connected in this matter?
Lordship, earlier I was appearing for respondent number 1 only.
Hmm.
So respondent number 4 and 5 was represented
No,
by
about
Mr.
this
Tiwari.
fourth.
Oh, yes, Lordship, you can. Yes.
So I did not appear
No, you did
in
not.
this connected.
No, you did not.
Okay.
My lord, if your lordship looks into the,
What do you want?
my lord, no, if your lordship looks into the contempt,
Hmm.
my learned friend is saying that there is no case which is made out in contempt.
They will consider that.
Yes, no, what I am saying, if your lordship looks into it,
Hmm.
the contempt application, please look into the contempt application.
Sir, you have filed a caveat. We'll hear you.
Oh, yes, of
Let
course.
us hear the
But,
learned
yes,
ASP person.
yes. Let him,
Yes.
not only
Now, my
contempt, my
lordship-
lord, he filed a
My-
writ petition.
I will
Yes.
address since my learned friend wants, I'll address the contempt first, my lord. Kindly have a look at the contempt.
No, then I should be hurt, my lord. If that be
I'm
the
not
case,
fair.
contempt, I should be hurt. In writ petition, he has got a locus to argue the matter. Contempt, I have filed.
I'll
I will
argue
show
both.
before the court. I will
I'm
show
just-
before this
my
court
lord,
there
may
is,
just
there is
be
a
5 minutes. My
contempt.
learned friend doesn't let
And there
me
is an
argue.
order
Let me begin.
passed by this court. Please look into the contempt because I have filed.
Sir, I'll hear you. Let
Yes.
us hear the
Yes.
additional Solicitor General first. It's his writ
Grateful.
petition. We'll come to the
No,
contempt.
that's
later.
why writ petition should be heard, my lord.
Huh.
Yes.
Yes.
Now, kindly have a look at the directions which are at page 140, my lords, of the writ petition.
140.
Now, these directions are dated, my lords may note the date. These directions are dated 10th of February 25.
Yes, yes. Please proceed.
Since Mr. Tiwari, learned senior counsel for the petitioner NHPC in writ petition 242 and respondents 1, 4 and 5 in writ petition 230 is agreeable to pay compensation to the respondent number 3 to 11 in writ petition so and so and the petitioners in so and so in writ petition 230, whatever they are entitled to under the 2013 Act, and since Mr. Das, learned senior counsel appearing for the petitioners in so and so and respondent number 3 is agreeable to accept the compensation whatever they are entitled to under the said Act, the court is inclined to dispose of both the writ petitions with the following directions. 1. A.
Sir,
The respondent
Sir,
number
where you are reading?
of
This is
page 140.
142.
140.
142.
I'm sorry,
142.
my
In
paging
court's
is-
record with 142.
I'm sorry, I'll rectify my record, my lords.
140, sir.
There are 23, my lords.
Yes, yes. Well, this is
The
142.
Directions are respondent number 2 and respondent number 3 shall constitute a board to reassess the compensation with the petitioners in so and so are entitled to and acquiring this land or at Bismarck Nagar as per the 2013 Act. So directions was assess the compensation, constitute a board. That board is to assess the compensation as per the 2013 Act. The board shall be constituted with adequate representation of the NHPC. C. The board shall assess the compensation in each of the component as specified in the first schedule of the 2013 Act in seriatim and further taking into account the provisions of section 29(2) of the 2013 Act, which provides for determination of value of things attached to land and building. The respondent number 2 and respondent number so and so on his satisfaction about compliance of all the provisions in assessing the compensation by the board and so constitution shall pass the award incorporating therein 12% interest per annum on the market value of the land as provided in the section 30 subsection 3 of the 2013 Act. The aforesaid exercise has to be carried out in the period of 3 months from the date of receipt of the certified copy of this order. This order was passed on 10th of April 2025. And the award was passed at page 1st of August 2025.
Yes.
In the meantime, my lords, if my lord has a look at page 176 of the contempt petition, the time was extended for passing of the award from 1/6 for a period of 2 months, my lord. That, my lords, will find at the page page number 176 of the contempt petition. So by August,
173.
yes,
Which contempt petition?
176.
Item 7. Item 7.
Item 7.
Now kindly have a look at page 179. It's an order dated 10/6/25, my lords. My lords have got it?
Just wait. Just one.
10th of June 25. 179 is the page number. It's an order on the IA, my lords. IA 149 of 25.
Which page?
Running page 179.
179, PDF page 180.
In IA. In IA. There's no 179 page.
Contempt. This is a contempt, my lord. A main contempt case.
Huh?
Not IA in a main contempt case. That's an additional affidavit.
There's no additional affidavit.
It starts from page 162.
See, contempt petition.
Ends at 161.
Contempt petition. Last page is 161.
Thereafter,
There
is
are 160.
Which I one.
It starts from 162. Additional affidavit.
Yes. One.
so 179 is the judgment, my lord.
Okay.
And it's dated 10th of June 25. Now kindly come to the operative portion. Paragraph 8, paragraph 5, my lords. Having considered the submissions of the learned counsel for the parties and considering that certain process has to be completed for proper assessment of compensation, and as agreed by learned counsel for the parties, I am inclined to extend further 2 months time for compliance of the judgment order dated 10/2/25, which I read. 10/2/25 is only for constitution of board and assessment and passing of the award. There is no direction to comply with the award so passed. Accordingly, further 2 months time is extended. So 2 months time from 10/6 will be 10/8. So
according to it, this is not for passing of the award. It's only for constitution and consideration of board to assess the compensation.
Yes. And
Okay.
and there's not, and this time has been extended by 2 months. But anyway, my lord, on 1st of August, the award has been passed. My lords may kindly have a look at. Now come back to the petition, my lords. That award is at 148. 158 of the main petition.
Your writ petition
Yes.
or contempt petition.
Writ petition, writ petition.
148.
158. My page is 160, but my lord's page will be 161, my lords.
Yes.
My lords, it is 1st of August. Now kindly look at the timeline, my lord. This court directs constitution of board and assessment on 10th of February 25 to be done within 3 months. That period is extended till 10th of August. Within the extended period, the award is passed. Now look at the date of the contempt application, my lords, and the prayer in the contempt application. 10th May is the date of the contempt application. page.
Of contempt petition again.
Yes. Page, contempt petition, date. 10th of May, my lords. And look at the prayer, my lords. The date is, my lords will get the date at page 16, 10th of May. Yes, my lord, signed on 14th of May, my lord. It is signed on 14th of May. Now look at the prayer made. Initiate, my lords are having page 15 prayer. Initiate contempt of court proceedings under section 10 of the Contempt of Courts Act, that is for disobedience, against the respondent contender for willful and deliberate violation of a judgment or order dated 10/2/25 passed by which I read. That was for constitutional board and passing of the award. Nothing as far as implementation of the award is concerned. That has been done within the time extended by this honorable court by 1st of August. One is the respondent under section.
But the award was not passed within the extended time.
It was passed within the extended time. 10/6 for 2 months it was extended. 10/8 it was passed on first. It was passed. Therefore, there is no contempt on the face of it.
2 minutes.
It was only against constitution. The order of the committee was constituted. Award was passed on 1st of August. There's
See,
compliance.
where is that extension order? Of
That
the
I
court
read in the
of this-
content matter, page 179, my lords.
179.
In the contempt petition. In that additional documents, IA documents, my lords.
Okay. Accordingly, further 2 months' time is extended.
Compliance of 10/2/25. The 2 months from 10/6 is 10th of August. For 1st of August, the award is passed. So there's compliance. Where's the question of contempt? It's a frivolous and vexatious application.
Okay. Okay.
This is one, my lord. Now I'll come to the writ petition. His case
So
that
your just wait. Your submission is that the order dated 10/4/2025 was extended on 10/6/2025
for 2
providing-
more months.
extending another 2 months. So the computation has to be, the period will start from 10/6, not
Yes.
from 10/4.
10th February. 10th February is the original order. Yes,
Okay.
it was,
Yes.
therefore, there is no contempt. And even otherwise, my lord, now his case is implement. There's no directions for implementing the award. And when he files
Okay.
on 10th, and when he files on 10th of May, there is no award pass. So the question of implementation on 10/5 would not
No,
arise.
10/4, what does it? It doesn't. It need not be. I mean, specifically to implement the award. When you said that you are, agreeable to pay the compensation,
But there has
that's
to be
why direction
direction.
was to complete the process. So, in fact, you are supposed to be completed within 30 days. 3 months.
That
3
was
months
done. That
initially.
extended period,
But
it
you
was
may
done.
have a point, prima facie, you may have a point. Once it is extended for another 2 months, that should be from the date of extension, from the
Yes.
date of order. And
Yes.
it is, subject to what the petitioner says.
Anyway, my lord, there is
Anyway,
no.
understood. Now come to the writ petition.
Yes, my lords.
Please come to the writ petition.
But this is an acquisition of land for the purpose of a hydel project. But this land, as far as possession of the land from the persons who have been affected, is not yet taken by us, because it will only take place after sometime before the lands get submerged. It will take about 7 to 8 months for submerging of the land. 8 years, 7 to 8 years. Sorry, 7 to 8 years when the lands actually will be affected. So they are still in possession. My lords may just note this only so that there is no urgency. I'm only pointing out as far as the urgency is concerned. Now, as far as the direction is concerned, my lord. Direction is concerned, and look at the award, my lord. Kindly have a look at the award. Absolutely cryptic, no reason, nothing.
Sir, where is the provision? So as that just because they'll be affected and
No, there's no provision. I'm not saying.
Next 5 to 7 years, there is no requirement of acquisition.
This was only with the purpose of saying that if the board is
If not,
directed
let us not have that thing. Let us not consider that, please. Then next, please.
Now, kindly have a look at the provision, 38. Since my lords wanted the provision, kindly have a look at 38 subsection, second provision to section 38 of the 2013 Act.
Anyway, sir, this is, you are challenging the award which you have not objected to.
We have objected to.
Was passed, and when there was a the direction of the court, you yourself has said we're agreeable to pay the compensation.
I'm agreeable.
And the order has been passed, sir.
Yes.
Just a minute, just a second. Now, when the contempt is filed, right? You move this writ petition. Is it not kind of circumventing the court's order? There may not be a violation as such. There may not be contempt as such.
But
you yourself
there
have
is no
said.
violation.
You yourself have said.
My
You
lords
have agreed. You are agreeable. Accordingly, are you challenging the quantum?
I am challenging.
Are you challenging the quantum?
I'm challenging the mode and method of computation and the improper mode of calculation, and even the quantum also I'm challenging. Exorbitantly. I'll tell my lords what my problem is. Kindly have a look.
Yes.
Now my problem is this, my lords may kindly have a look. Firstly, give me that bullet point. But this award has been passed to benefit a private party. Because
obviously, you are
not
taking over the land.
Not the victims. Third party. I'll tell my lords why.
Sir, at this stage, we cannot go into it once you have agreed to pay. And if you are, agreed by if you are challenging
why
if you are not agreeable with the quantum,
why it is required.
I think appropriate forum is there, sir. I need not tell you.
No, kindly have a look, my lord. Kindly have a look at how the award has been passed. First, kindly have a look at the award. What is the reasoning? No reasoning at all. Kindly come to 160.
Yes.
Kindly come to page 160, my lords. No reasoning at all. 165.
Why reason is required? Why reason is required, sir? You have taken the land of the people, and then you, in the judicial in the litigation, you said we are agreeable to pay the compensation.
We are still agreeable to pay the compensation if it is properly adjudicated and assessed and decided. My lords may say it is not adversarial in that sense. But
in that case, if you are agreed by the contempt and not agreeable to the quantum of the compensation, is there any provision to challenge except the writ petition? Are you saying that it is not a case of reference because you are not an interested person?
There is an alternate remedy, I agree. But here the award itself is bad on the face of it. Kindly have a look at the award. Kindly have a look at page 160 onwards, 163, and how it has been done, my lords. 165, sir. 165.
160? 65.
Of your lordship's paging.
Yes.
Now, kindly have a look. Look, first, with 1 page earlier, they give location description of total land area, valuation of land. That is the second paragraph. Third is determination of compensation. Now see how the compensation has been determined.
Page 167.
And award summarized total
Joint
value
measurement
variance.
of the land was carried by the committee and distributing all other board members. It means all the people and all this concerned.
On what basis? What is the rate? Nothing.
Basically agreed by this quantification of that.
Now I'll tell my lords what is the grievance, my lords. Main grievance. Nothing. It is absolutely a cryptic award without any
See, sir,
reasoning. Nothing.
The determination of compensation has also been done
Nothing.
as per a period time value of some property assessed by board has been taken 100% so and so. At least
That is
something
only
is
the
done.
figures. That is only the figures. That is only the figures. Nothing. What is the reasoning?
Where
Why
you-
they were
where
at?
you
Now
were-
tell my lord.
Were you
My
a
lords,
member of the board? Sir, were you a member of the board?
My officers were members of the board.
Can't help it.
No, my officers
Difficult,
were
sir.
members of the board. My lords may kindly have a look further, my lords. We wrote letters
Sir.
objecting. We wrote letters objecting, my lord. Those letters are there. We wrote letters objecting. Those letters are there.
At best, sir, today we may issue notice at best. Nothing
well,
else.
my lords,
In fact,
my lo-
I'm not inclined.
But my
It is
lords may
something
issue
you
notice.
you have passed the order pursuant to the order of this court award on of course deputy commissioner in your presence on your full participation on 08/01/08
But we objected.
2025.
My lords may
And
issue
now-
notice. Let them come back.
After 10 months or 8 months, what is 8 months? You are coming with the writ petition that it has not been properly passed. Who
But
has,
there is
who
a-
has, I mean,
It is. I'll
Who
tell
has
my lords
stopped
what it
your-
is.
and there appears to be under the law, there is an alternative remedy also.
No, that alternative
As
is
you-
not an efficacious
as
remedy,
you know-
my lord.
as you
Where
know,
the
sir,
where the order
as-
itself is bad. Now
As
kindly
you
have a
know, sir, this land compensation, it's a beneficial legislation. Taking
We are
over the
benef-
people's land.
We are ready. We are not against that. We are willing and ready to give the compensation provided it is fairly and correctly decided. If it is unfairly decided in favor of a third private party, then of course we have to object. I'll tell my lords what it is. Now kindly have a look at, my lord, page number.
See, when the verification was done by your own showing, you are the member and the
No,
affected persons were
proper
there.
verification was not done.
Can we, how
government
can you
now,
say now?
Now kindly have
Have
a
you
look at
filed any
two-
objection, sir, at
kindly have a
at
look
that
at two
moment?
provisions, my lord. Kindly have a look at two provisions. At page.
Yes, Mr. Das. No, I am not
My lord,
inclined.
well,
Will
I-
issue notice,
my
will
lord,
provide you
I have-
opportunity to
My lord,
response.
my lord, your lordship is right. Whatever your lordship has fallen from your lordship, mouth, that's what I have prepared. Now, question is, I have a full objection so for issuing a notice. Why they
Issuing
have done
notice, you
only
I can never have
please,
objection, my
please,
lord.
Mr.
No,
Raju, I didn't disturb
No.
you.
No,
Mr.
no, I'm
Raju, I
saying
didn't disturb
issue
you.
notice.
No,
Issue
please,
notice,
do
there
not
can't be any
disturb.
objection.
This is my lord is asking me, I have a right to give a reply.
If there's any
I have a
interim
right
relief,
to
that's a
give
different
reply.
matter.
My lord is asking, please don't interrupt.
Yes,
I
just
did
wait.
not. I did not
Relax.
disturb. My
Relax.
lord, your lordship is that, please see, my lord, the first, they want to circumvent the order of the contempt. That's why this writ petition has been filed. Absolutely, that's right. My lord, with great respect, I am using this word after 40 years of my experience, a mockery of this court by filing this writ petition. Only for the purpose that now there is a contempt. My lord will kindly say last order which has been passed by this court. The order of which my learned friend has read, what the court has said, that order I will just take your lordship to the order that has been passed by this court. Let's
Sir,
go
let
to
us
that.
do one thing. We'll issue notice.
My lord, what they will do,
By three,
no, what they will,
file whatever.
no, what they will, no, what they will do is,
Because obviously,
No, no, what-
KBN,
no, no,
do not have.
no, what they will try to do it. They
Let
will
the
say
state.
they will say they have filed for that purpose, for issuing notice so that contempt. My lord,
Contempt
they
is
will
otherwise
say-
not
Now,
maintainable. I've demonstrated. I need not have filed.
My lord, he is not allowing me also. I will show before this court why this contempt, there is a contempt, my lord. I'll show that. First, let me place this, my lord, why there is a contempt. Please take, selectively my learned friend has not have annexed certain document, selectively he has not annexed those documents in the main writ petition. Now I will show the contempt, kindly see. I will say it is a full contempt. My lord will kindly see, my learned friend read one paragraph of the judgment. See the order of this court at page 17 in the contempt application. Please take the contempt, my lord.
17.
17 of the order that has been passed by this court.
Page 17.
Page 17 of the contempt. My lord will see that
It's a judgment.
judgment, yes.
2, 3, 2, 4 and 2,
Correct.
3.
On the basis of which, my lord, award was passed. At page, my lord will kindly see this, and what contrary, my lord, the writ petition has been drafted and my lord structured. Kindly see paragraph 20, page 26, my lord, of the judgment, 9.2. Lordship got it? 9.2. At page 26. At page 26, 9.2. 9.2. Mr. Tiwari, however, admitted, though the land is acquired under section 10 of the regulation 1947, yet the compensation cannot be awarded under the Act of 2013, and the petitioner is not aggrieved on the said mode. In view of the decision of division bench of this court in so and so, but the petitioner is aggrieved in awarding 25% of the net present value of the awarded amount as per the State Rehabilitation and Resettlement Policy 2008. 9.3. It is further submission of Mr. Tiwari that the petitioner NSPC in WPC number so and so is ready to pay compensation to the respondent number 3 to 11 as per the entitlement under the Act 2013, and therefore Mr. Tiwari has contended that the impugn award dated 6/11/2018 by which 25% of net present value was awarded to respondent number 311 is illegal, arbitrary, and section 107 of 2013 never authorizes the respondent number to award any compensation under the State Rehabilitation and Resettlement Policy 2008, and therefore Mr. Tiwari has contended to set aside the impugn order or to modify the same by deleting the net present value. Now today, in the writ petition, they have taken that point that the rehabilitation resettlement policy is applicable. And in this case, they are saying that no, it is not applicable.
May I
Kindly
only
see
submit this,
further-
Mr. Das, one minute, one minute.
there's
my lord. May I only
once
submit
I
one
point
thing, my
out
lord?
then,
One thing,
kindly
my
see
lord,
para
it is to your
11.
benefit.
Why
Mr.
is
Mr. Das,
taking
it
the
is to your
advantage out
benefit.
of it when
It is
I
to your
arguing the
benefit.
matter?
Let me submit something which is to
My
your
lord,
benefit.
what
Now,
you
we
have
are
already
ready to-
submitted.
We are ready to
Kindly see
deposit.
paragraph 11, my lord.
My lordsman,
Paragraph
kindly have a look.
11.
We are
At page
ready to
29.
deposit the amount of compensation without prejudice to our rights. In this court, let it be in this court, my lord. We are ready to deposit the amount.
See para 29, my lord. Kindly
then
see
the
one
writ
second,
petition may
para
be heard.
29. My lord, see para 11 at page 29. On the other hand, Mr. Das, learned senior counsel petitioner in WPC also subscribes the submission of learned advocate general in respect of so and so. So the so and so appeal lies. Now kindly see at page 30 to 11.2. 11.2, my lord. At page 30. 11.2. Further submission to Mr. Das is that petitioner WPC 230 are ready at page 30, my lord. What you got it?
30.
11.2.
Of what?
Yes, 11.2. Further submission of Mr. Das is that petitioner and WPC are ready to accept the compensation under the Act 2013 if the NSPC has assessed the compensation in total compliance of the provision for assessing the compensation laid down in the schedule of so and so, and award the compensation under 29 or for the forests and crops standing on the acquired land, and the deputy commissioner has rightly assessed the compensation and the same request no interference be before this court. Now at page 31, the issue is what my lord kindly see, and this issue now my learned friend in this writ petition has taken up this issue, R&R policy.
See, the reason I am inclined to issue notice is the action of the state or the collector passing the award has been put to challenge. Though I am not inclined as such, I mean, I don't find the writ petition to be, but then we'll have to give them
Kindly, my lord,
opportunity to
just,
respond to
yes,
them.
yes, my lord, only one thing, if your lordship allows me,
Huh.
why I'm saying, my lord, one cannot take a ride of the order that has been.
No, why not?
No,
even
your lordship is right.
just issuing
No, no, I know, my lord, but kindly see, I don't mind that lordship issues a notice in this. What I am on, contempt, kindly see this contempt, my lord, this, I'll show before you, that's why I'm arguing on contempt. I'm basically on contempt, my lord. Lordship will see one letter of the NSPC, whether it tantamounts to contempt or not. One letter, my lord. Your lordship is right. 2018, when the notification was issued for acquisition, whether they have raised all this point, that the land is in excess, this is what they are projecting in the writ petition. So RNR policy is to be adopted. Why they have not raised all this point? Today, we are in 2026. Once the order is passed by this court, in a land acquisition matter in the state of Arunachal Pradesh.
On next date, we'll dispose.
So,
We'll grant them a time.
can I just
with the
put it in this way, my lord? Let this matter be fixed on next week, and your lordship will take a call on this
whatever
petition.
the state.
State, yes, my lord.
But, before issuing any notice, whether the writ petition is maintainable. My lord, here the acquisition process has been done under the Zoom Land Regulation, Section 10 of the Zoom Land Regulation. Although the quantum has been quantified under the LARA Act, but acquisition is under the Zoom Land Regulation. Under the Zoom Land Regulation, there is a provision for appeal against the award passed by the collector. Now, when there is a provision under the Zoom Land Regulation, how a writ petition be maintainable? Just to circumvent what the contempt proceeding. And in this particular,
See, entertainment of the writ petition, just because there is an alternative remedy.
Yes,
that is the writ jurisdiction. We have, I mean, ample power.
Yes,
It's
that,
why
here,
it's just
There's
Supreme
a
Court also-
finding in this very matter that writ is
just
maintainable.
wait, sir. Just wait, please. It's a self-imposed
restriction. Prima facie, the award has to be, the order has to be the challenge.
not on the alternative remedy, but I find it's not an
Here,
writ petition.
my lord,
But
here,
we are granting you
my lord,
time.
further,
And this
further
amount-
they have.
Let the amount be deposited before this court. As Mr. Raju has said, let the amount be deposited
Why
before register.
necessary? You will-
No, this is the amount. No,
You
this
will
is
not
amount
listen.
which the landowner, now he is changing his particular, he said himself.
Same.
He is changing his himself.
We
said.
will give to the victims, not to third parties.
What is the
We don't want a third
what is
party.
the amount?
The amount is 48
48
crores an odd amount.
You deposit
Yes, before the
within
register.
1 week.
All
right.
Within
1 week name deposit.
Your
and let
own statement.
Within 3 weeks,
But
within 3
here-
weeks,
Yes.
within 3 weeks we'll deposit. 3 weeks we'll
For
deposit.
what? 3 weeks, my lord.
2 weeks. 2 weeks.
They are
3
a
weeks.
corporate sector.
2 weeks.
My lord, here,
We are doing public work.
No,
my
while
lord.
issuing notice, whatever you want to say, you say on next
in
day.
the same locality, they have already acquired for 22 persons. This is for 41 persons.
It's okay.
Same, they have already
see.
paid.
My lord,
Okay.
there is a letter of the NSPC where clearly in contempt 187A, my learned friend is not showing that. See 187A.
Now,
letter, my
Leonard friend
lord,
may
that
either finish the argument. He's never ending, my lord. He's never
Yes.
ending.
Yes,
What is the area? How much is the area?
142 hectares.
At Bismarck Nagar?
Yes,
Okay. Okay, we are issuing notice.
yes.
You file your detailed affidavit, whatever, we'll consider.
My lord, let them deposit the amount.
Yes, he has, it's so.
Within
Yes,
3
let
to
them
4 weeks
deposit.
we'll deposit. But
There has
within
to
3
be-
to 4 weeks we'll deposit. 3 to
2
4
weeks.
weeks.
2 weeks.
But
No
2
weeks.
weeks is a
2
little
weeks
different.
will. Because we'll take up the matter after 3 weeks.
Yes, sir, 2 weeks.
Before the matter is taken up, we'll deposit within 3 weeks. Before the next,
my lord will
after
give a
3
clear
weeks, my
direction
lords may
within 2
post it.
weeks. Let
Before
them
the next
deposit.
date of hearing, we'll deposit.
Had Mr. SB Raju, learned senior counsel.
ASG, my lord. Learned ASG.
Oh, AG,
Yes, ma'am.
learned additional solicitor general, assisted by Mr. K. Saxena,
And
learned
Mr.
counsel for the,
Rajat Nair.
and Mr. you
Rajat
just
Nair.
keep-
I'll
Hmm.
give.
Rajat Nayak.
Nair.
In caveat is there.
Yes.
In caveat, you says heard the caveat so heard Mr. So and caveat is then the church. Challenge this writ petition is to the award. Where is the award? Sir, where's the award?
I'm sorry, my lord.
Where's the award?
Award, my lord, at page 162 in the petition, my lord.
160.
Writ petition.
161.
161.
This is in submission over there.
Award your lordship will find.
This is an
Yes, it's 165.
Same here.
165,
but the order is same. It's
165.
0108-2025. Passed by the
Yes. 182,000.
Deputy Commissioner, Collector, Lower Dibang Valley District, whereby a land measuring 142.6 hectares situated at Bismarck Nagar, Koronu Circle, page 167, has been acquired for a total compensation amount of rupees 48,45,00,537. Pursuant to the order of this court passed in WPC 230 of 20 230
and 242
of 20
the 2020 one is 230 is 2024
then
and
242
is 2020
and WPC 2030 of 2024 by an order dated 10/04/2025. Well, simply issue notice, nothing else.
And but the amount should be deposited, my lord.
My lords, we will deposit the amount.
Yes.
We will
Yes, let it
deposit
be
the amount
deposited.
before the next date of hearing, my lords. There is no
No,
difficulty.
no.
We'll provide 20 days, within 20 days.
Very
20
well, my lord. That's almost 3 weeks. We have no
20 days.
difficulty.
Within 20
We have no
days.
difficulty in that. My lord, let the state government file its affidavit because state government would be
Yes,
the necessary
obviously,
party.
they will issue notice returnable by 3 weeks.
Please, my lords.
3 weeks.
Grateful, my lords.
Returnable at 3 weeks.
Let it be 2 weeks, my lord. I will give a reply.
My lords, the private party is too anxious, my lords. We want the state government to come on
Too
record, my
anxious?
lords.
Don't tell anxious. You have fooled us for from 2018 to the year 2026.
Just wait, sir.
We are from state of Arunachal. That doesn't mean whatever the NSPC will do it, they can do it of their own.
Since Mr. N. Ratan Lanet, Additional Advocate General, enters appearance and accepts notice on behalf of
1 to 4.
Respondent number 1 to 4 and Mr. Didas, Lanet Senior Counsel, assisted by Mr. Lanet Counsel. Also appears for Respondent 5 to
13.
5 to 13. No formal notice in this. How exclude is findings to the learned counsel for the petitioner. Next para. Considering that the compensation, the award has been passed on being agreed by the learned counsel for the parties in earlier round of writ petition, which amounts to and consent order. And as agreed to by learned AG, Mr. Raju, to for depositing of the compensation amount, comma, it is provided that the petitioner shall deposit the awarded amount of rupees 48
Crores.
48 crores. Only thing, my lord, consent only with respect to the
before this court within 20 days.
Yes.
consent is only with
We'll give
respect
you
to
a fixed
the.
date because
My lord,
There
after
is no
2 weeks,
consent with
I will
respect
find
to the
reply.
earlier
3
award.
weeks, sir.
Yes.
We'll make it 3 weeks.
My
After
lords may
3
just
weeks, sir, we'll
modify
give
the
you a
order, my
date.
lord.
Only so far as passing of fresh award was concerned.
Consent was only with respect to passing of the fresh award. There was no other consent given, my lords.
No, that is my view. I'll say the prima facie. Prima facie.
Prima facie.
That
My
is my
lords,
view.
very well.
Subject
Subject to
You are
what I
considering that the award is passed prima facie on so and so agreed amounts to consent order, huh?
That's a submission made by Mr. Raju. Well,
No, that is
I am
what I
saying
said
that it
is.
is not. I am not agreeable.
No,
to
he is
this.
ready to deposit, but what I find is that the award has been passed on agreeable by the parties in the earlier proceedings. Prima facie appears to be a consent order.
correct.
And
Absolutely
as
correct.
agreed by the learned AG.
Only with respect to passing of
for
the award.
deposit.
Correct.
Only with respect,
Right.
not with respect to determination.
After
Not with
3
respect
weeks,
to
only come an award.
determination.
Sir, that's why I'm saying, I said prima facie.
Very well.
Prima facie.
Date here, so,
Yes.
My
List
deposit
along
is
with-
without prejudice to my rights, my lord. Deposit is without
Oh.
prejudice to my rights.
Obviously.
Grateful, my lord. One
Well,
line
after
maybe
We're
stated.
adding that, huh?
After
Obviously, the matter is pending, so without prejudice to
But
the
my
right
lords may
of
say
the
it is
petition.
deposit is
we'll
without
withdraw.
prejudice.
We'll withdraw.
Yes.
My lord, the matter can be listed on 9th. Days after 3 weeks. March 9th.
You give the
Master Raju, I think whether it is
Okay.
on 9th.
Ninth is okay.
Yes. I think we have got both.
on
9th, we have got a matters, I think. Both we have a matters in Nagaland.
But my lords may just say it is deposited without prejudice.
Ninth.
For one line, that's
9th,
all.
I got it. 9th. 9th,
Yes, I'll add that. Obviously, even if
Yes.
I don't mention it also obviously, because the matter is pending. All right.
Yes.
That will be on 10th, my lord. If it is not inconvenient to my lord.
You agree with that?
10th is Tuesday.
Tuesday would be
10th.
very difficult. for
Tuesday is very difficult. Supreme Court, there are, it's like a,
11th. 11th.
11th is all right. 11th. Maybe at some time adjustment, otherwise 11th.
On next date, we'll dispose of the matter, and I request Mr. Raju, learned AG to, make you convenient to be present physically, so that we
My
can.
lords, it is difficult. Then I'll ask, I
My
will
lord.
give a date my lord, when I can remain physically present. My lord.
No, I'm
No,
just
no,
saying, I'm
that's-
just saying, because we cannot disturb you from, appearing through BC. But
My lord,
it
any
is-
Saturday my lords are working? No.
No,
No, nothing Saturday. Mr. Raju has to come alone in the court Saturday.
so it is
The
fixed.
agreement-
You just give that date.
So 11th is okay, I think 11th.
11th, huh?
Yes.
11th March.
11th March. I might ask for a little adjustment of time.
We're
otherwise
adding
11th
that,
is-
huh? The deposit
Maybe,
of the
maybe a
amount.
little half an
Now
hour
this
here or
court
there, but
shall-
11th.
Shall be without prejudice the right of the petitioner, without any prejudice.
Yes.
Obviously, whatever you mentioned, his task.
Yes. It will be
Grateful.
deposit here, Register General.
Ah.
Register, my lord, to all, Register of this court. I am deeply obliged, my lord.
You
Contempt,
may
my
put
lord,
it in
if
an
let it be
interest-bearing
placed-
FD.
I-
You may
I-
put it in
I
an
never thought
interest-bearing
of
FD.
that.
my lord.
Since the alleged counsel for the senior counsel appearing by petition, I cannot help it out.
My lord,
Otherwise, it's not an appeal. Why should?
My
my
lord,
lord, let it
ask
be.
the
I mean,
registrar
he
to
may be
deposit.
right. It is amounts to a money decree also.
Yes, yes. There is an alternate remedy is there. My lord, your lordship point.
There's
My
no
lord,
alternate remedy. I'll
my
point-
lord,
I'll
this
express on all
contempt,
points,
This
my lord.
contempt will list
together.
list the
Together, my lord.
along with
Yes.
item 7. Contempt so and so, huh?
But
I
the
think,
money
my
may
lord,
be deposited in a
it-
fixed deposit in a nationalized bank.
No,
But
no.
I have-
Register.
Mr. Raju, I have checked out. Earlier, this court has found that there may be a contempt, but on your own submission, on your submission only and without hearing the other side, I find prima facie there may not be a contempt.
I'm grateful. I'm obliged. my lord.
Please,
Prima
please
facie
take
again.
I will
I'm
show my
obliged,
lord how it is contempt. How it
Of
is
course, I have
contempt.
not heard you.
Yeah, that's why your lordship has not heard. But how it is contempt, once my lord, the CMD comes here in the court, I was satisfied. The CMD will come in this court. Yes, then everything will be
that is
settled.
the
I know,
oblique
my
purpose,
lord.
my lord. That is the oblique
This is
purpose.
no oblique.
The oblique purpose
Your
is
oblique
this.
purpose, your oblique purpose is to frustrate the contempt.
Thank you, Learned Senior Counsel.
Deeply obliged, my lord.
Your
Grateful.
friends are in the queue.
Right.
My lord, one indulgence, my lord, not this matter. 26, there is a matter, my lord. There, if it can be taken up any other day, my lord. I think my learned friends are there. He is my.
Item 26.
If it is not inconvenient to your lordship, my lord.
No, no.
I have taken other side, my lord.
Item 26.
Yes, my lord.
Pleadings are complete.
Yes, now I have filed, we filed a
But this is order. Somebody, you asked somebody to be there.
Yeah.
Huh?
Yeah.
This for listed for orders. We'll see.
Yes, yes. I am there. If your lordship wants me, I can be there. My
No. What is to be done? What orders need to be passed?
No, orders means, my lord, the pleadings. I have filed an affidavit in this case, my lord.
Okay.
The affidavit has been filed. But we are praying for an interim on the next date, your lordship will consider.
Okay. On the prayer of Mr. Did as Learned Senior Counsel, let this matter be listed after 2 weeks.
Yes. On
11th.
Not 11. My lord, there is a holiday there in Guwahati. Can it be on 3rd of March? 3rd of March. 3rd of March, my lord.
Yes.
I'm deeply obliged, my lord.
No, this will not pass any order. List the matter along with contempt so and so. I've told him. Told her.
Item number 2.
Lordship, this is connected to eviction notice, my lord. So petitioner here is the health assistant. And during the 2012, she has been allotted a government quarter. Now, respondent authorities has issued a notice for vacation for the regions of dismantling and reconstructions, my lord. So that notice
Dismantling and redevelopment.
Yes, redevelopment. my lord.
Must be quarter must have been outlived
That was issued to me on my lord 12th of January, and then on 30 I have received. And in that notification, my lord, I have been expressly promised that during the dismantling periods, I will be re-accommodate or alternative accommodation will be provided. But just after 2 days of receipt of the initial notice for vacation, just after 2 days, that is on 2nd of February, executing agency has issued another vacation notice with the direction that it has to be back at within 15th of February, or else a necessary action as per prevailing law will be
Today is
taken.
what?
But today's, my lord,
Can we turn the clock back?
so my lord, it is now that deadline is over. So at any time, a necessary action may be initiated against me. That
Why
is
have
hence.
to come earlier? We cannot do anything now.
So, Lordship, pursuant to that, Lordship, I have approached the concerned respondent authority with the representation on 5th of February. my lord.
See, it's good for you. Suppose if the quarter outlives, right? It's the life of that quarter. It's risk. There's a risk involved.
Yes, my lord, here in this, I have very limited prayer.
Also, they want to redevelop.
Yes, my lord.
Obviously, once it is done, you will get.
Yes, my lord.
Your entitlement.
I have a very limited period
Very
prayer in this
Very
case.
difficult to interfere in such a case.
Because only on the ground that, my lord, right now, my children are having ongoing examination. So at this
What is your
period,
what your children are? Which class?
Class 7 and class 9. Class 7 and class
When
9.
is the exam is?
Exam 1 is class 7's exam is ongoing, and class 9's exam will be commenced from the 6th of March. That is the hardship, my lord. In addition to that, I have elderly
Still-
tree ailing.
We're not concerned.
Yes, my lord. So that is the reason behind only I am before, because I have that very grievances has been approached before the concerned authority for consideration certain period, my lord.
See,
So
court
that-
order cannot be passed basically on sympathetic ground.
Yes, my lord, I understood.
We cannot be swayed away by the emotions and sentiments. It's a good policy of the state. It has outlived. Now they want to redevelop. It's for you only.
Yes, my lord, that's there. But then
It's not for the
very
deputy
short period
commissioner
of,
or chief secretary.
that's very
They
short
have their
period of,
own bungalows.
yes, my lord.
It
But
is for you only.
But only my humble prayer is that it is very short period to relocate, because in the subsequent second notice, they have not whispered about relocating or reaccommodating me. So within this 10-15 days, it is very hard
I
for me.
understand individually, but sitting here is very difficult.
So it's the drastically affect to the ongoing examination children, my lord. So I just
And
pray
the
for
notice was
time
issued on in
extension.
the month of January. You
But
know that
yes.
your children's exams will be somewhere in the February or March.
I received that on 30 of January, my lord. I have been served on 30 of January, and subsequent notice was on
Yes,
2nd
madam.
February.
What can we do? I'm not inclined, but then since the children are
Yes, Lordship.
having their
otherwise,
exams,
Your Lordship has rightly pointed out the quarters are in dilapidated and crumble condition, Lordship, structures are. So, Lordship, in the page 25 also, Lordship, annexure 2, it says that the government employees whose quarters are dismantled shall be provided alternate temporary
where it is,
accommodation
where it
by
is,
the executing agency.
where
Or,
it is,
Lordship, 25, page 25.
page 20, yes.
This is, my lord, initial notice, my lord.
Government employee whose quarters are dismantled shall be provided alternative temporary accommodation by executing agent or able HR.
HRA. Till
Yes.
the place are constructed.
These are the
Lordship, he should have availed this, Lordship. He's
Here.
supposed to avail this, Lordship.
My lord, this is the notice
After the
issued.
places are completed, they will be accommodated. They will be given the first priority slot will be, Lordship.
This is the, my lord, notice issued by the Director of Housing, and the executing agency is, my lord, Directorate of Urban. That is page number 26, my lord. Next page. There, in this is the second notice where I am directed to vacate by the 15th of February. In this notice, executing agency has not whispered about
who is the
alternative.
executing agency?
Commissioner
that is-
Affairs, this is by the Commissioner Urban Affairs. This
Kindly see, my lord,
page 25 is.
third para, my lord. The second para, in this regard, it is to inform you that the Department of Urban Development, Itanagar Division, has entrusted to execute the work within the stipulated time period. As such, LOT occupant presently residing in the said quarter are requested to vacate by 15 February 2026 for the possession and facilitated dismantling. The next para, kindly please, my lord. Failure to vacate the quarter within the stipulated time shall compel the department to take appropriate action as per rules in force without further notice. My lord. So in this second subsequent notice, the executing agency has not whispering about alternative
No,
accommodation.
this is the next.
Say it again and again. Since already they should have, and then this notification in the notification, Lordship, the petitioners' names are reflected, Lordship. Two petitioners in serial.
Can you take instruction whether they have been provided with the alternative or alternative temporary accommodation
Lordship, that I can.
tomorrow? Because once you have decided to provide them, without, providing them, after all,
Lordship, in the notice, it says that alternative temporary accommodation.
or avail HRA. You have to provide HRA or else provide them alternative temporary accommodation.
Yes,
By
Lordship.
tomorrow, we'll take it up tomorrow. Huh?
Lordship.
Only on that part.
Yes.
Difficult. And you are two here, two petition.
Yes, my lord. That is connected to some.
And there
same
are 8
notice.
persons.
8%.
8%, my lord.
Once you pass a slightly positive order, so everyone will rush. We cannot,
They might
we
have,
cannot open the floodgate.
Others might have vacated also, Lordship.
Ah,
Since in the notice it already says that alternate accommodation.
So, my lord, here,
and
this-
Mr.
Pitamini, my lord.
Learned Counsel for the petitioner. By this application, petitioner seeks to challenge the notification dated 12 January 12/01/2026 and passed by the Commissioner within bracket Urban Affairs bracket close page 25, huh? Whereby an order has been passed to pave the way for redevelopment of government housings in various sectors of Eternal Capital Complex, whereby general quarters of general pool, all quarters of general pool located in this sector, Naharlagan, has been notified for dismantling and construction of multi-story plates allotted to 8 persons, including the petitioner. List of the petitioner has also challenged the letter requesting for vacation of the government residential areas quarters. It said, aforesaid government residential quarters dated 02/02/26 passed by the executive engineer within bracket UD bracket Eternal Division to 8 persons, allottees of 8 persons, including the petitioner. List of although this court, upon hearing the learned counsel for the parties, although this court is not inclined to issue notice, considering that the notification dated 12/01/2026 provides that an alternative temporary accommodation by the executing agency or avail HRA to the allottees of the dismantled quarters till the flats are constructed. I deem it appropriate to direct the learned additional senior government advocate, Ms. M.S. Giate, to obtain instruction as regards the temporary alternative accommodation or HRA.
HRA.
This is the matter tomorrow on 19th.
Obliged.
Same order in
Item number
item number 3.
3.
Obliged.
Deeply obliged, my lord.
Item number 4.
My lord, I'm sorry, my lord. Item number 26 has been mentioned. Here I am hearing for respondent number 7 and 8. My name may be recorded.
Record. R.B. Yadav, Mr. R.B. Yadav, learned counsel for respondent number 7 and
8.
7 and 8 is present.
Your Lordship, the respondents are yet to file their affidavit.
Yes.
Lordship, I'm on behalf of the Standing Council for Education, Tabatale. We are yet to receive.
2024, it's a case of suspension. It's a case of suspension only. If you have not taken the review, I mean, if the review has not been done, he has a right. We'll direct them to reinstate. Where is Mr. Tagum?
He's out of station, Lord. He's out of station, Lord.
Where he has gone?
Not aware.
Huh?
I'm not aware.
You must ask him where you are going. Your senior. You must know his whereabouts. Anyway, what can we do? You are also not ready.
No, sir.
You are not also ready to argue the matter.
No, appearing on behalf of Mr. Tara, Your Lordship.
Huh?
Appearing on behalf of Mr. Tara, Your Lordship.
Mr.
Tara, Titi Tara. I'm appearing on behalf
Item?
Number 4.
Number 4.
Mr. Titi Tara.
Yes, Your Lordship.
On the joint prayer of Mr.
Pironia, Your Lordship.
Learned Counsel appearing for Mr. Titi Tara and Mr.
Eltika.
Learned Counsel appearing on Mr. T. Tagum, Standing Council Education Department, as well as MS P. Sangeeta, Learned State Council. List this matter after 4 weeks. Huh?
No issue, Your Lordship.
Sure.
Okay.
4 weeks.
No issue.
Man is the petitioner is under suspension from since 2024. Anyway, 2 weeks.
Yes.
In the meantime, respondents to file their affidavit in the position. Before the next date. 3 weeks. We'll make it 3 weeks.
Okay, Your Lordship.
Lordship, similarly in item number 6.
What is this? We'll see. 6 also you are taking time.
Yes.
You have not filed the affidavit.
No, I'm there yet.
On the prayer of Mr. Eltika, Learned Counsel appearing on behalf of Mr. T. Tagum, Learned Standing Counsel, Education Department. List this matter after 3 weeks so as to enable the state respondents to file their affidavit in opposition.
Item number 8.
Yes.
The respondent are yet to file counter affidavit in this matter.
Transfer matter.
Yes, Your Lordship.
Why you are not filing affidavit?
There is
There is a stay operating.
the standing counsel is there in this matter.
Who is the standing counsel?
Brother B.P. Child.
You have not retired.
No, I'll be retiring on 30/6/2027. 30 June.
No, the interim order was passed on the ground that you are having a little about 1 year, 2027.
Yes, Your Lordship. It is specifically mentioned in the petition. Your Lordship. Even then, Your Lordship, only 1 year.
Mr.
Ibam, Your Lordship.
Ibam, Learned Counsel for the petitioner. Non appears for the petitioner, state respondents. Nor any affidavit has been filed. List the matter after 4 weeks. In the meantime, the respondents may file their affidavit.
Interim
order passed earlier shall continue.
Much obliged.
Item number 9.
Yes.
Lordship, I need some time to file affidavit, Your Lordship.
What is the matter?
This is a matter relating to the ALC service. Superannuation on at any age of 45. After filing of the writ petition before His Humble Court, the age was determined 60 years for retirement. After filing of writ petition, the respondent authority installed my service. And after that, again released from the service, saying that you're across the 60 years. That is the case.
Now,
now I am challenging.
You are in or outside that service?
I have been,
In or out the service? Out of the service.
I have been already discharged from the service. Age by their version, but age per my contention, my age is 55 years now. 5 months to be remain in the service. That's why I filed the present writ petition, and I'm challenging the date of birth maintained by the authority.
What is your date? What is your date? What
in
on which basis that you are
age per my contention, my date of birth is 25 June 1971.
You have the date of birth?
Yes, I have in my earlier petition also. I meant I included my date of birth certificate 25 June 1971. The authority they maintain my date of birth without any basis. 1963. On the basis of 1963, on 19 April 2022, I have been released from the service on superannuation.
Date of birth?
Today I have filed one additional affidavit, page number 30.
From where you have obtained date of birth?
My lord, after filing of WPC 19 of 2022, the respondent authority used my service date of birth age 1963. Then I filed RTI. In that RTI reply, the respondent authority saying there is no such document. Rather, they asked me to provide the original certificate of date of birth. Accordingly, I provided. Before that, I have already part of the birth certificate and same was in the record in the earlier writ petition. And again, I submit that same birth certificate in this additional affidavit, page number 30. And 31 is...
It's very urgent. You immediately file.
Yes.
Only five years to go.
Yes, only salary is only 15,000 only. ALC, lowest of the lowest service. Now, authority honestly harassing me.
You'll get, if you are reinstated, you'll get 18,500.
Yes, now 18,000 almost.
Heard Mr. Tito, Learned Counsel for the petitioners. Petitioner?
Yes, I'm petitioner.
Only one?
Yes. Earlier, 3 petitioners and 2 are in the service. They reinstalled their service. But unfortunately, my service has been released, saying that I have attended 40 years, 60 years.
Very bad. A spread for by MS Arbasar Learned State Council. Further, 2 weeks time is granted. You file immediately.
Yes, it's ready, Your Lordship.
2 weeks time to file affidavit. List after 2 weeks.
Item number 11.
Lordship, here also we need some time to file affidavit, Your Lordship.
Yes, Mr. Yadav. What is the matter here?
The money has been recovered after his retirement.
Okay. What is the post? What is your post? What was your
junior engineer?
Junior engineer. Okay. Already recovered.
Already
recovered.
Okay. Heard Mr. R.B. Yadav, Learned Counsel for the petitioner, and also heard Ms. T.T. G. Tarak, Learned, standing on the BD. On the prayer, M.S. Arbasar, Learned, State Council, that this matter be listed.
3 weeks. 3 weeks, Your
3
Lordship.
weeks, so as to enable her to file affidavit. Like.
Item number 12 and 13.
What is this IA about?
Your Lordship, IA is for stay of the further process of the examination. For stay of the further process of the examination.
What examination?
The examination report of junior engineer conducted by the APPSC.
When it is likely to be?
It is to begin from 9th March. They have already declared the prelims result, and now I am praying for the further process of the examination, which is to begin from 9th March.
Why?
Because Your Lordship, the issue in this case is, Your Lordship, before I come to the IA, the item number 12, may I please apply Your Lordship with the main suit, item number 13. In this main case, Your Lordship, we are challenging the advertisement dated 17/9/2025, conducted by the APPSC. Now, the issue in this case is we are raising the issue of irregular and illegal seat reservation in respect of the persons with disabilities. How it is illegal, Your Lordship? They have given reservation only to certain categories of PWDs, and not given any reservation for the other categories. May I please take Your Lordship to page number 28? That is the advertisement, Your Lordship. And the relevant portion is page 29.
Why you have not asked for the interim order on the day?
No, exactly. Your Lordship. Yes.
Lordship, the IA which they have filed seeking stay of the recruitment process was already rejected in the main writ petitions.
Your Lordship,
So this IA is not at all maintainable, Your Lordship.
on that aspect, Your Lordship,
Stands rejected.
yes, Your Lordship.
Once the prelims were, I mean, the written examination.
By the time the exam was, by the time,
rejected, after that, how can we
No, Your
say the further proceedings?
no, Your Lordship, by the time when this order was made, the exam was yet to be conducted. And if we look at the order, Your Lordship, the first order, may I read, Your Lordship, the first order?
I have read it.
Yes.
See, that is next is what? It's a Bible verse.
Yes, Bible say.
Then
now
once it rejected, how can in between we just pass an stay of the further proceedings?
Because this first order, it only says that this premature to give any stay at this stage, because it is too early. That is the examination made, Your Lordship. But today,
you file an appeal against this order or file a review against this order.
but Your Lordship, that today the situation is different, Your Lordship.
See, you have sought for a stay of what? Stay of what? Stay of the written examination or what? Entire selection process.
No.
What you are stay? Where you are asking for a stay?
In the main petition, Your Lordship.
This during the examination of the post of reserve categories may be stayed or to stay the result declaration of advertise on respect of reservation for so and so. Publish as when the original notice of correction before the exam is conducted.
Yes.
It's all over now.
But Your Lordship, the situation today,
Situation and the result has been declared.
Yes.
Next thing is the Bhabavosi interview.
That is exactly, Your Lordship, what I'm praying for, Your Lordship.
How can you stay there?
No, because
in the midway, you have not participated.
I participated in the examination, Your Lordship.
Then?
And because of their because I have been deprived, because my seat.
You have participated.
I participated.
And you have been selected, or
no? Some of us has not been selected, and we have not been selected because of the deprivation they made to us. They did not make any kind of seat reservation for us, Your Lordship.
Have you filed affidavit in there?
No, Your Lordship.
You filed
notice? Yes, Your Lordship. In the main petition, Your Lordship.
Yeah, main petition. Which page you are showing?
The page number 28, Your Lordship. 28, and the 11% is page number 29, Your Lordship. 29. That is serial number 4. That is junior engineer civil. And to the left side, Your Lordship, they have reserved the
page 29.
Yes, Your Lordship.
Junior engineer.
Yes, and they have reserved 8 categories for the persons of blindness and low vision that rise at Your Lordship. And again, they have reserved 4 seats.
Blindness and low vision.
Yes.
Deaf and hard of hearing. Then
only to this, they have given reservation only to these 2 categories. I am locomotor.
Locomotive.
Yes. And why they have not given any reservation to any other category, Your Lordship? Because this is in total violation of the Rights of Persons of Disabilities Act 2016. The 2016 PWD Act, Your Lordship, it clearly says that 1% each has to be reserved for all the categories. I have this Act, Your Lordship, if you're... Section 34, Your Lordship, of the Rights of Persons with Disabilities Act 2016.
Your how many candidates have been selected for these two benchmark disability?
The details I don't have, but they have already declared the registered. The four candidates for blindness and low vision. Again, 4 candidates for deaf and hard of hearing. No candidates from other categories are selected. Because it is clear favoritism to this only to these categories. Now, what about the other groups, Your Lordship? There are so many other benchmark persons, locomotor, mental illness, cerebral palsy. What about them, Your Lordship? So this is clearly violation of the this Rights of Persons of Disabilities Act and deprivation to the other categories.
Yes, madam. Why only 2 categories?
Lordship, in that regard, Your Lordship, I'm yet to receive the parawise comment, Your Lordship.
Because minimum section
34.
34.
Yes,
Lordship. Today, the matter
page
was
number
listed.
16 of the Act.
Every appropriate girl shall appoint in every so not less than 4% of total numbers of vacancies in the cadre strength in each group of post mean to fill with person with benchmark of which 1% each shall be
1%
reserved
each.
per person with benchmark dignity and blindness and low being, deep and hard of hearing, locomotor disability, autism, multiple disability. Let them file affidavit. Why this has been? You may be correct. At least 1% each.
Yes,
Of course, subject to 4% of the total vacancy.
And one more issue.
And how they have worked out, I don't know. They must have worked out something. It's not question of favoritism or something like that.
But
wrongly they might have they might have misconstrued or the provision, or maybe the 1% each doesn't mean that all of you will be filled up. Subject to 4%. Total vacancy, 4%. Every recruitment year. And then the each from that each benchmark.
Yes, but
each category.
Yes, Your Lordship. But the whole percentage being given to one group.
I don't know.
And one
let us have the affidavit.
In that case, Your Lordship, may I pray that let them file affidavit within the period of 1 week. And the matter will be fixed for final hearing on 2nd March, Your Lordship, before the examination, Your Lordship. Otherwise, Your Lordship.
You file?
So yes, Your Lordship will file at least some more time may be given, Your Lordship.
Let them file
10 days, 10 days. You just work it out, that's all.
Then
why you have given only 2 categories?
Lordship.
It's a matter of right.
And
PWD, it's a matter of right. You
file.
cannot afford to, just bypass like this.
Your Lordship, one more is
As per the requisitions, Commission has advertised and accordingly they have conducted the exams. We'll file our affidavit, Your Lordship.
because now Your Lordship, the APPSC Even their manual says when it is not in
Who
conformation
has
to
issued the advertisement?
the APPSC.
Advertisement was issued way back in the, Your Lordship,
2025.
it was issued on 17/9/2025. They have approached after.
In between emails, so many representations, Your Lordship, which they had not even considered.
Advertisement is of September.
Who has to work out this? APPSC or the department?
Both the commission and the department, because commission has advertised as per the requisition, Your Lordship.
Now,
as per the reservation done by the
Then
departments, Your Lordship.
that
State. You filed the affidavit within 10 days. How you have worked out? Nothing else.
Your Lordship, even this.
All the department.
Yes.
This is a particular department or what?
No.
In general.
Yes.
See, obviously, I mean, you might have worked out. These are the posts reserved for this category, that category. In view of that, they may, but whatever,
Lordship.
all of you file within 10 days. All right. Heard, Mr.
K. Taja.
K. Daja, Learned Counsel for the petitioner. How many petitioners? Huh?
4 petitions. 4 petitioners.
Learned Counsel, MS N. Anju. Who is one? Who is?
Out for 2 and 3, Your Lordship.
N. Anju for respondent number 2 and 3. Respondent and Public Service Commission, respondent number 2 and 3. And who you are representing? No, who is for 1?
State.
Why did I for respondent number listed council for respondent number 1, 5, 6, and 8? Why not? And Mr. Committee 7?
7, anything.
And 4? Comma Mr. So and so. Tigadi. And 7?
Yes.
G. Tarak. And Mr. Perme, standing council. Huh? G. Tarak, all are standing council, huh? Except Y. Rirab. Huh? And directed to file their affidavit within 10 days from today as the matter pertains to claim of reservation of the PWD, huh? In terms of the what is this? Right of Persons with Disabilities Act 2016. Yes. List the matter on
2nd March, Your Lordship. For final hearing, Your Lordship.
3rd.
2nd March, Your Lordship.
3rd March.
Your Lordship, I only.
You don't have to answer everything. Yes,
Yes.
Mr. Tara.
Yes, sir.
How you have calculated
Yes.
from each department?
Your Lordship, the one issue is that it is the fault of the APPSC because they cannot blame the other departments.
No, that's why she is also filing. She is also filing.
Yes, Your Lordship.
Reservation, I think they will be worked out by the department only.
Because Your Lordship, when it is not in conformation to the prescribed laws, the APPSC manual clearly says that they have to return it to the department. But what they have done without.
You are not against the department.
Basically, it is, I'm against.
They have done. I mean, if they have.
No, basically, I'm against the recruitment process.
Wrongly done.
No, I'm against the process adopted by the APPSC, Your Lordship.
Then why you have made them a part?
Because it is from the department, Your Lordship.
So.
Then we did not file.
On 2nd March for final argument, Your Lordship.
Huh?
2nd March for final argument.
Not final argument. It is listed for admission.
Yes, Your
That we can be disposed of.
Obliged.
Admission stage also.
Item number 14 and 15.
Order little fast. Huh? Yes.
May I please, Your Lord? Also, this is long pending matter, my lord. And basically,
Why it's been pending for so many years?
yes, my lord. On several.
Why this has been listed for orders?
No, my lord. On the last occasion, my lord, if lordship perused the order dated 17/12/2020.
Affidavit in opposition has not been filed
My lord,
on behalf of respondents.
respondent.
No affidavit, why?
My lord, may I clarify that aspect?
Here, Your Lordship, we have received the Parval's reply, so we need some more time, Your Lordship.
May I clarify, my lord? That is the whole contentions of the respondent authorities that Fairwise comment has been received. It is a case of 2019, my lord. My lord, by order dated, if Lordship peruse the order dated, my lord, 17/12/2020, wherein, my lord, the state respondent has categorically made a statement before this noble court. It has also been reflected in the order sheet that, my lord, the affidavit filed in other similar cases
Item 15.
will, my lord, cover in the present case also, my lord. So therefore, my lord, the copy has to be served upon to us by the state respondents, wherein, my lord, they have filed affidavit. My lord, there are so many other matters wherein, my lord, the similar questions are involved, my lord. So therefore, my lord, at this stage, my lord, may I pray that matter may be, my lord, since the learned AAG is not available today, my lord. So, my lord, matter may be posted for tomorrow, and the copy may be, my lord, the served to me.
Sir,
for-
only two matters when it was supposed to be listed.
My lord, earlier it was, my lord, the club together, my lord, take together, my lord. There has been again, my lord, the separated, my lord.
No, separated. If it is separated, they should file an affidavit. In the
No,
in
my
your
lord, that will be
separated-
covered up, my lord, as per their suggestion, my lord, the
No,
submission.
that was when it was together.
My lord,
When it was listed, supposed to be taken up together.
my lord.
Now, when it has been segregated, why this has been segregated? As is not similar.
Similar, but, my lord, some of cases are similar, some are not similar, my lord.
No,
My lord, in this
see, once it is segregated, it's
Well-
difficult. What is the matter?
matter is, my lord, basically we are, my lord, agree by the, my lord, the impugn, my lord, fact finding committee report, my lord. There is no procedure that's under the Lara Act, my lord, and the even Zoom regulation, my lord. In that case, my lord, what happened? Fact
What is
finding
the
committee.
fact finding committee? Of
Commit-
what?
Fact finding committee to ascertain, my lord, the valuation and the, my lord, the properties reassess, my lord, something kind of, my lord, reassessment from, my lord, stage of land from 14 to Bopi, my lord.
Oh.
That issue, my lord. Some, my lord, fact finding committee is against us, whereas they have used one term, COS, my lord, compensation oriented structure, my lord. Whereas there is no such, my lord, under the statutes, my lord. So, my lord, by that,
Ultimately, fact finding committee is not under the Lara Act.
true, my lord.
It is on the basis of the complaint and the cases which has been initiated. So it's the fact finding committee or whatever is to trace out whether in fact there was irregularities or not. The rest will follow. This is under investigation only.
Yes, ma'am. Kind of investigation by the
ED
administration.
has taken up the matter.
Kind of investigation by the.
It was transferred to ED or ED has intervened.
Yes, my lord. In some cases, my lord, the ED has been
So if
intervened,
we-
and charge sheet has also been filed by the SIC, and my lord,
Any fact finding committee
my lord,
to find out whether the allegations are correct or not.
true, my lord.
That cannot be under the Lara Act.
Yes, ma'am. But my lord, that another point is there is no procedure, my lord, as such for fact finding committee, my lord. Fact finding committee is just to assess, my lord. They assess, gone into the depth of my lord assessment and gone depth into my lord, so many other things which has not been required to be done, my lord. By that way, my lord, it is found that yes, petitioner has received the excess amount though in calculations to their, my lord, properties, my lord. And that way, my lord, we have been given a directions for, my lord, the repayment of the excess amount, my lord. So therefore, basically, we are challenging. That is one aspect. Another aspect, my lord, what we have taken in the pleadings is, my lord, fact find order of the, my lord, the government, state government, is basically for the inquiry in respect of certain stage of, my lord, the road, certain stage of, my lord, road, and, my lord, this, my lord, case of the petitioner is not covered under that, my lord, orders, my lord. This is different, my lord, stage of land, my lord. Order was for basically for other.
Since you have segregated it, let them 1 week time will grant.
Yes, madam.
You have received the instruction.
Yes, Your Lordship.
Heard Mr. M. Kato, Land Counsel for the petitioners. This will be common order, 14 and 15. Since Ms. MS PP Pang Leonard, State Council has received the instruction on her prayer, further 1 week time is granted to file affidavit. List the matter after 2 weeks.
Malad, they have said it on 9th, Malad. More than 2 weeks.
Yes.
9th March. Deep level.
Oblige, Your Lordship.
Item number 16 and 17.
Yes. Hello. Correct is very good here. Long order is evidence. Yes.
Yeah, Your Lordship. Here in this case, Your Lordship, all the required affidavit replies have been completed. So now the matter may be fixed for admission.
How? It's a contempt case. Have you complied with? Till that no affidavit in reply has been filed on behalf of the petitioner. Are you supposed to file reply?
Respondent number 6 has to file reply as per the last order.
Lordship reply, I'll not file, Lordship. Matter may be posted for admission hearing because Lordship here they have partly admitted, Lordship.
You have complied or not complied with?
Which one, contempt one. For that, Your Lordship, we have already filed our affidavit.
Saying what?
Saying we are not violating. We are not violating the order.
Let us see why you have not violated.
For that, Your Lordship, kindly it may be fixed on admission.
You can take it up on orders also. See, contempt, we'll have to see whether there is a contempt order. Once you, if we find that you have violated, the two willfully violated the court's order, we'll initiate contempt. There is no two other way.
It may be kindly taken up on admission.
Lordship.
Kindly.
When?
After.
Oh, it is submitted by Mr.
M. Kambo.
M. Kambo, Learned Counsel, appearing on behalf of the contempt, Alice contemptor, that affidavit has been filed. However, since Mr. Arsener has some personal difficulty, he pressed the matter list after 2 weeks. We'll consider.
I need a fixed date, Lordship.
And
Because on 5th of March.
has agreed to learn counsel for the parties that this matter be. After that, before that, you write her name.
5th of March.
So and so. Diet, learned additional advocate general for the petitioner. Then you said, as agreed to by learned counsel for the parties, list the matter on 5th.
5th, Lordship.
06.
Friday.
Item number 18.
This will be with
along with the
WPC,
WPC, Lordship.
Yes.
But in this matter, respondent number 1, 2, 3, they have not yet filed affidavit.
Yes.
Respondent number 4, we have received counter affidavit.
We have filed affidavit.
Well, you have filed. You have received.
2 we have filed.
Heard Mr. S. Learned counsel for the petitioners.
Petitioner.
Who else have not filed? You have filed?
Yes, Your Lordship.
It is submitted by MSG Arbasar Learned State Council that an affidavit on behalf of respondent 1, 2, and 3.
2, Your Lordship, DC, we have.
Respondent number 2 has already been filed. Yes, you are.
Lordship, I'm for private respondent. Respondent number 4, Lordship.
You want to file?
I have filed only, Lordship.
We have received today.
Then you said Then 1 and 3,
Oh,
this will cover.
yes, Lordship, it should cover your Lordship.
What is the issue?
Basically,
Claiming compensation.
no, not claim compensation. Issuance of land position certificates.
Okay, so this will be enough.
Yes.
And then you write, heart so and so, huh? It is submitted at the bar that an affidavit in respect of all the respondents have been filed. Just accordingly, this is the matter for admission after 2 weeks.
Obliged.
Item number 20.
Yeah.
Your Lordship, your Lordship, I'm appearing on behalf of the party for the petitioner. Your Lordship, I have received affidavit in opposition by the respondent 1, 2, and 3 and 4. So,
who is appearing for it?
Your Lordship. So we need time for filing affidavit in reply, Your Lordship.
Heard Mr. So-and-so, Land Council appearing on behalf of Mr. T. Pertin, Land Council for the petitioner. Yes, who is appearing? For 1, 2, 3, and 4? Tabatagum. It is submitted by Land Council that an affidavit in opposition has already been filed on behalf of respondent 1, 2, 3, and 4. 2, 3, and 4.
1, 2, 3, and 4.
3 and 4. Huh? Office note dated 17/02/2026 reflects that neither ID card nor unserved notice has been received in respect of respondent number 5. List the matter after 3 weeks, awaiting service report.
Much obliged.
Item number 21.
May I please, Lordship?
Yes.
Lordship, here we have to file objection, Lordship. Lordship,
Land Council for the petitioner. You have no objection.
Yes.
On the prayer, Mr.
Ketabang, Lordship.
Land Council for the opposite party. Further 2 weeks time is granted
Lordship,
to file objection to the IA 265 of 20.
May Lordship. Lordship, fixed date may be given.
After 2 weeks?
Lordship, since there is a violation of impugn order, Lordship. So there is
that is
item 21, Lordship.
Then why you have filed an IA?
As Lordship, I have filed IA for implement.
Okay.
I am not the party, Lordship, in the writ petition. However, I am the interested person. So the present
objection is required.
Lordship, there is some. So, Lordship, they are alleging us, Lordship, that which is baseless, Lordship. So
then you have been granted at least twice or thrice to file objection.
Lordship, actually, this petitioner, they was performing this ritual restriction, Lordship. That's why, Lordship, on 26, Lordship,
see,
26 February.
21, 22.
Lordship.
2 also.
Yes, Lordship. Yes, they are connected, Lordship. 26 February, Lordship.
Not 26. After 2 weeks.
Lordship, then
or will allow the implement.
Lordship, will file objection, Lordship. Kindly.
When you have been provided with
Lordship, this petitioner, they was performing this this ritual restriction, Lordship. And yesterday we have received the instruction, Lordship, from the petitioner. Lordship.
Very strange.
Lordship, then on.
And before that,
Lordship, there's this.
How long you are in the thing?
There was a holiday, Lordship.
Don't make you unnecessary, useless excuses.
Sir, Lordship,
Anyway,
can it be on?
after 2 weeks. 2 weeks.
Deeply obliged.
Item number 23.
This is 21 and 22. You write separately, huh? Same order, but separately. Yes.
In this matter, we have to file a counter affidavit.
IA is for what?
IA is for modifications to interim order, Lordship.
On the prayer of Mr.
Tinuki.
Learned counsel for the opposite party writ petitioner.
Lordship,
Further 2 weeks time is granted to file.
IA,
objection.
my IA, Lordship, if that's not considered, Lordship, then because
He wants to.
it was filed long time back and they took 3 times to file the objection,
As
Lordship.
a last chance.
Last chance. Much obliged.
Item number 24.
Mr.
Lordship, a fixed date may be given, Lordship.
Estapin Learned Senior Government Advocate and Miss MS.
Waigaon Lordship.
Huh?
Waigaon Lordship for the
Waigaon.
private respondent Lordship.
Are present, huh? You choose the
Better fix on 3rd of March, Lordship.
3rd of March.
We have a matter in 3rd of March.
We are not concerned. What matter? Here.
Yes.
So,
In another court, lower court.
On 2nd, Lordship, then.
The Friday, me. The Friday.
Friday, on 2nd.
next. Second of March.
Lordship.
May I please, Lord?
Yes.
Item number 24.
Affidavit in respect of
4 and 3 and 5.
3 and 5.
Who is 3 and 5?
Yes, I am for the 5. Lordship, we need to file. We will file it. My lord,
Then 3 is Deputy Commissioner, Lordship Magistrate.
Like upon the affidavit filed by the power party.
Okay.
agree.
Heard Mr. H. Lampu, learned counsel for the petitioner.
Sorry, agree, Your
Huh?
Agriculture Department.
MS, Mr. Y. Ramlan stated on submitted. Although no affidavit is filed on behalf of the respondent number 3, the affidavit filed on behalf of the Department of Agriculture shall be sufficed and would be relied upon. This stuff. Mr. On the prayer of Mr. G. Kai, learned counsel for the respondent number 5, further 2 weeks time. 2 weeks.
Let it be last chance, my lord.
2 weeks time.
This is a matter of
affidavit.
question of back wages and reinstatement, my lord. Last chance, my lord.
24.
Yes,
2025, let's see.
Let it be on 9th of March, my lord.
9th of March.
Yes, all right. Oh, let's move.
Item number 25.
May it please, Your Lordship.
Yes.
I am for the petitioner.
Hmm.
The respondents are yet to file their affidavit.
Yes.
Your Lordship, we have
Are
already
Mr.
filed, Your Lordship.
Huh?
We have filed our counter affidavit, Your Lordship.
Then who else has to be filed?
There is respondent number 4.
Who is respondent number 4?
Respondent number 4 is the power of attorney holder.
Have you, notice has been served?
Yes, Your Lordship. I have taken steps and
Where is it? Respondent number 4. If they are not filing, forget it. Huh? Heard Mr. A.K. Bhattacharjee, A.A. Bhattacharjee, learned counsel for the petitioner. The respondent, state respondents have already filed their affidavit. Next para. Although the respondent number 4 is represented by a lawyer, none appears today on his behalf.
Your Lordship, here is a
List
interim
after
passed
forward.
earlier.
Interim order passed earlier shall continue.
Much obliged.
Obliged, Your Lordship.
Item number 27.
My lord, we'll be needing some more time, Your Lordship, to file our counter affidavit. I'm appearing on respondent number 5. We have
And
entered
one
our
of the state has filed.
Not yet, Your Lordship.
Heard MS? Madam,
Yes,
Your
leading
name,
counsel is in court number 5.
anyway,
Coming.
you are appearing on his behalf.
On
Yes, your name, please.
ES Nidamari. ES Nidamari.
Learned counsel appearing on behalf of, your name is there, no?
Yeah, my name is there.
Your name is there?
Yeah.
Learned counsel for the petitioner is spread for by, no, on the prayer of Miss P. Sangita, Learned State Council, and MS D. Tamuk, Learned Council for respondent number 5.
Yes, Your Lordship.
Further 3 weeks time is granted to file affidavit.
Much
Just
obliged.
after 3 weeks.
Yes.
Item number 28 and 29.
Yes.
Your Lordship,
IA is for
is for striking out of the petitioner. Striking out of the petitioners.
striking out. To whom?
Petitioners.
Petition number 13, Your Lordship.
Okay.
Not only 13 years.
Oh, Your Lordship, no.
13, 5, 15, 6, 10, 4,
Yeah, well, so
14,
no objection.
No objection, Your Lordship.
Heard MS,
MLA.
Learned counsel for the applicants. Your the applicant is what?
Applicants
Are the petitioners?
no, Lordship. He is a withdrawing petitioner. Withdrawing petitioner.
Withdrawing petitioner.
Your Lordship, they were petitioner in writ petition, Your Lordship. Now they
They
are
are
wanted to strike out their name.
Okay. They were the petitioners, huh?
Yes, Lord.
And Mr. Waideram, London State Council for and you are also appearing.
No, Your Lordship. See it.
Okay. This is an application seeking striking out of the petitioner number. You just tell the number.
13.
See, why don't you say serially 4, 5, 6, 10,
15,
10, 12,
12, 13, 15.
13, 14, 15. Eight.
Yes, Your Lordship.
In the WPC. What is this WPC? 338 2024. Next para. The petitioners, the applicants along with some other petitioners have filed the writ petition being WPC 338 of 2024. What is the writ petition about?
For the question inside a set of illegal impugn preliminary notification that it's yes.
Regarding Your Lordship, preliminary notification of forest area, Your Lordship.
What I said?
6/8/2019.
Writ petition being WPC, na? Challenging the preliminary notification issued by
Issued by issued by government.
Issued by whom?
May I also the writ petition basically dealing three things. Preliminary notification proposing to constitute scheduled land as VFR, Village Forest Reserve Area. And second thing, the certificate of mutation. And the third,
No, you
the
just
proclamation.
challenging the preliminary notification constituting village forest reserve, huh?
Yes.
Yes.
Comma,
The certificate of mutation.
certificate of mutation,
Mutating the land in the name of the state environment.
and
third, in the proclamation.
and proclamation issued by which authority?
Authority.
Arey yaar.
Page number 51 of the writ petition.
Nothing is
Principal Secretary Environment and Secretary.
preliminary notification.
Yes, sir.
Page
50 also.
Principal Secretary. That is, you just mentioned the preliminary notification that 6/08/2019, huh? Then the mutation, huh? Right? Mutation. Principal Secretary Environment Forest, huh? Then
64.
where is the mutation?
Petition,
Get page 64.
64 euro.
54 to 65.
Mutation by then comma. Deputy Commissioner. Mutation certificate of mutation, huh? 18 December 2017. Deputy Commissioner by Deputy Commissioner Dibang Milyani, and
then proclamation is 1/7/2024, page number 81 to 84. Your Lordship.
proclamation by Deputy Commissioner.
Yes, Your Lordship.
Yes, Your Lordship.
Deputy Commissioner.
81, Your Lordship.
81 onwards.
81 onwards.
Then mutation certificate of mutation will be first, huh? Then preliminary notification, and then proclamation. First 01/07/2024 by Deputy Commissioner. Huh? Preliminary notification by principal this thing. Then rest is by Deputy Commissioner. Huh? Claiming and on the ground that they were the landowners, huh? Landowners.
Yes.
Mr. However, during the pendency of the writ petition, the applicants came to know that they are not the landowners.
Yes.
That is your.
Yes.
They are not the landowners. Therefore, they would not. Therefore, they are no longer interested to pursue the writ petition. As such, please, next paragraph. Having considered that the applicants are not the landowners for which preliminary notification as well as the preliminary notification, comma, mutation certificate of mutation, comma, preliminary notification and the proclamation have been issued by the authorities, and considering that they are no longer interested to pursue the matters, as well as agreed to by learned counsel for the parties, this application is allowed. List accordingly, the name of the applicants, so and so, same number, be struck off, struck off from the area of writ petitioners. number so and so, huh? I instance disposed of. Yes.
Obliged.
Then writ petition.
Yeah, Lord, so we need to file the praise course title. Speaking of the-
Acha. In writ petition, huh? In view of the order first so and so, huh? That's all.
Item number 31.
May it please, Your Lordship.
Yes.
Lordship, conducting counsel, Mr. Pangin has some health issue today, Lordship. Kindly this matter may be taken up tomorrow, Lordship.
This court is also having some health issue.
My lord, I have no issue. It's a question.
You have no issue.
My lord.
Either for adjournment or for
Because my lord,
or
other counsel is my lord.
health wise.
Health issue, my lord. That
You
is
have
my
no
lord.
health issue. And you
I have no health
with
issue
the
and I have no issue on the adjournment, my lord.
Okay. Okay.
Tomorrow.
On the ground that leading counsel Mr. Deepang has is in this first today. Mr. D. Learned Counsel submits appraised that matter will be lifted on 19th. We are not being objected to by 19-2, huh? Mr. Prayer not being objected to by Learned Counsel for the respondents. Let the matter be listed on 19th. Huh?
Obliged, Your Lordship.
Item number 32 and 33.
So we'll take it up at 2. We'll dispose of the matter. Huh? 2. At 2. These are only 2 matters.
Yes. It is.
Why 2 writ petitions?
Another one is, my lord, upgradation, my lord. In between representation, it was disposed of, my lord.
What upgradation?
Earlier writ petition challenging the transfer,
When the matter was pending, your representation was disposed of.
Disposed of.
Rejected.
Rejected, and I was
Where's
directed.
the question of upgradation?
So therefore, my lord, that subsequent one challenging that.
No, why I'm saying, I'm just asking, why you are saying upgradation? It happened.
Item number 32 and 33.
This is, my lord, transfer matter.
Yes.
The basic issue, my lord, here in this case is that the respondent number 3, with whom I have been replaced, is not a of similar cadre post, and he is at all not eligible. And since this is, my lord, transfer method, if I have been replaced by some competent officer, my lord, then I am ready to go, my lord. Here in this case, my lord, I am additional deputy conservator of forest. Additional deputy conservator of forest. Let us, my lord, kindly come to page 31 of my writ petition.
Where is the impugn order?
It's at page, my lord, 46, my lord. And also page 52, my lord. The disposal of representation.
No, this is yes, we're taking up the WPC.
445, my lord.
445.
my lord.
Yes. Page
31, my lord. We are saying, my lord, there is a violation of
No, this is
statutory rules.
This is recruitment rule. I mean, this is a rule.
Rules, my lord, governing
Forest service rules.
forest service.
Where is the impugn order?
Impugn order, my lord, at page 46, my lord.
Common transfer order.
Common transfer order, my lord.
Your name is
My name is my lord.
16 July. Year is also not mentioned.
Here is also not mentioned, my lord.
2025.
25, my lord. My name is serial number 3, my lord.
Hano Moda.
My lord.
ADCF.
DAPO Pasigat to DAPO Silviculture, my lord.
Vice Sri.
Telling Tucker, he is also ADCF. He is now DAPO 0, my lord.
You are also posted as DF only.
DF only, my lord. That I admit, my lord. Now, kindly, my lord, to understand.
ACF mobile squad, CAG Pasigat, DFO Pasigat.
That's serial number 6, my lord. Here also, my lord, ACF, to my understanding, my lord, this respondent number 3, whose name appears as serial number 6, has not born yet in the cadre of ACF, my lord. Kindly come to page 31, my lord.
Now let us assume that he is ACF.
My lord.
He is not ACF also.
He is not ACF also, my lord.
Then
He
why
is not
shown as ACF?
My lord. It should have been ACF on probation, my lord.
No, it's okay. Let us not go that much. Let us not go unnecessary.
Because, my lord, the service rules
ACF means ACF.
My lord.
Whether in probation or not, unless he is discontinued or terminated.
My lord, but then rule says that initially
It's a transfer posting. Let us see.
My lord.
Come to the relevant. Unnecessary, let us not. ACF may be a provision. Is it ACF?
ACF probation.
Doesn't matter.
My lord. Kindly come to page 31, my lord. Yes.
Yes. This is Arunachal Pradesh Forest Service rules.
My lord.
Yes, then.
Section 3, my lord. Constitution of service and the classification. There shall be constituted a state forest service to be known as Arunachal Pradesh Forest Service, my lord. 2. The service shall have the following 4 grades, namely entry grade, my lord. That is ACF, my lord.
When do you get it ACF?
ACF, my lord, through direct recruitment, also through promotion, also, my lord. Respondent number 3 is promoting, my lord.
So from where do you get it? This is ACF.
That, my lord, page page 49, my lord.
No. In the rule,
my
how
lord.
do you say that it is entry grade is ACF?
I'm coming to that, my lord. Kindly take note of.
Come to that direct.
ACF entry grade, my lord, and then senior grade. I am in senior grade, ADCF, my lord.
No, you said entry grade is ACF.
My lord.
From where you get that it is entry grade?
This is not disputed, my lord.
I just wanted to know,
my lord.
sir, since you are saying so.
Just a minute, my lord. Rule 28, my lord. Here there is an indication of entry grade, my lord. Every duty force shall be held by a member of the service, provided that a duty force in entry grade, my lord, or senior grade of the service may also be held by an officer in the junior scale of the Indian Forest Service cadre of Joint Agmut cadre.
Sir, can you tell us, how do we know that this entry grade is ACF?
Therefore, my lord, page 49, my lord. On the basis of recommendation of the DPC meeting held on 9 March 2020, the Governor of Arunachal Pradesh is pleased to order promotion of the following range forest officer to the post of Assistant Conservator of Forest, that is entry grade, my lord.
It's okay, this is promotion order.
Entry grade,
I just wanted to know from the rule. It doesn't indicate anything.
Entry grade.
Anyway.
My lord. Entry grade, that is not disputed, my lord. So ACP is the post, that is entry grade, my lord. And thereafter, my lord, next promotion is, my lord, senior grade, that is
There is no
ADCF.
dispute.
This is not disputed.
You are ADCF?
My lord.
And his
ACF, my
response number 3 is ACF.
My lord.
Which is the entry grade. Yours is senior grade.
Senior grade, my lord.
You are higher in cadre.
Cadre, my lord.
You are first in higher cadre. Yes.
Then, my lord, all those expect it's Rule 21, my lord. When some promotee is given the post, that is for probation for 2 years, and that can be anytime discharged.
No.
Or reverted, my lord.
Not concerned.
Not concerned.
From rule, can you show that ACF cannot be posted as DFO?
My lord. Kindly come to page, my lord. 40, my lord. This is, my lord, part of rule, my lord. Schedule 1. I am concerning with Schedule 1C, my lord, at page 40. Post under additional deputy conservator of forest as attached officer in various forest division as under 19 post. At serial number 3, my lord may kindly see. ADCF Pasigat, my lord. So Pasigat is forest division, my lord, wherein ADCF can hold the post as attached officer, my lord. And therefore, my lord, in all other this like Namsai, Bomdila, Itanagar, all these posts, the posts of DAPO, are being posted by ADCF, senior grade, and serial number D, my lord. Here also, my lord, would find it entry grade, my lord. Post under Assistant Conservator of Forest, entry grade, as attached officer in various forest division as under 22 posts, my lord. Pasigat is not there, my lord.
Yes.
And thereafter, my lord, this impugned order when it was issued, I have filed representation, my lord, by ventilating my grievances. That is at page, my lord, 50, my lord. May I read, my lord? The representation for retention in Pasigat Forest Division. Sir, I have the honor to submit this representation in connection with the latest transfer and posting order of IFS and Arunachal Pradesh State Forest Service officers by number so-and-so, dated 16 July 2025, whereby, among others, I have been transferred from Pasigat FD to Silviculture FD Itanagar. In this regard, while respecting the government order in the interest of public service, I'd like to request you for my retention in Pasigat Forest Division. As per Rule 21B of AP Forest Service Rule 2019, on promotion to SFS entry grade, ACF from RFO, an officer has to complete mandatory 2 years probation, during which such ACF probationer is normally posted as ACF, attached to DFO or CCF office. And after satisfactory completion of 2 years probation, the service in ACF is to be confirmed by Departmental Confirmation Committee as per Rule 24 of Service Rule. However, it's seen that Sri so-and-so, ACF probationer, has neither completed his probation nor confirmed in service to the post of ACF as per the rules, service rule. Further, NT, that is R3, was not transferred and posted as ACF to other division following his promotion to ACF, but has directly posted as DFO, Pasigat from range officer, Pasigat, thereby passing over the intervening period as an ACF. On promotion to higher rank, it is seen that normally an officer is transferred and posted to other district division. Here, Sri so-and-so, ACF probationer, is posted to the same forest division after promotion to ACF, where he has already served for altogether 15 years as range officer in all 4 different forest ranges under the Pasigat FD. He has already served as RO Mebo range, RO Rukshin range, RO Nari range, and RO Pasigat range. Furthermore, if exigency of service arises, the same may be addressed in other way, one of which is by assigning dual charges to eligible officers. At present, Sagali Forest Division and Bandardo Forest Division are headed by one DFO. AFD Namdapa NP is taking Mebo Wildlife Sanctuary as additional charge. If at all there is exigency of service, there are eligible senior officers.
Okay. Yes, I've read it.
My lord. So
your only grievance is that just he's on probation and lower in rank, he could not have been posted as DFO.
My lord.
By replacing you, who is the post which is to be held by the ADCF.
My lord.
That's all.
That's all, my lord. Thereafter, my lord,
in terms of the schedule of the rule.
Schedule of the rule.
Schedule to the rule.
Schedule to the rule.
That's all.
Therefore, my lord, I'm saying there is a violation of statutory service rules, my lord.
Not exactly on transfer and posting.
Even transfer posting, my lord, if entry grade not yet born also, I am ready to go, my lord, if some eligible person is replaced in my place. And if this type of practice, my lord, not intervene, my lord.
How long you were there?
More than 2 years, of course, my lord. So page 52 is
4 years. 3 years.
3 years, my lord. More than 3 years. 8 February, my lord. It's almost 3 years. As on today. Page 43, my transfer order. Now, very interestingly, my lord, while disposing of this, representation, the grounds that state respondent they have taken is different. But then while filing affidavit in opposition, my lord, they have come up with some new ground, saying that the Pasigat is a designated territorial area for IFS Kedar, as per IFS fixation of Kedar strength amended regulation 2022, my lord. So, therefore, I am also not eligible. So, meantime, I have taken records of all the designated places, that is in total 11. Those are designated for IFS officer. But surprisingly, my lord, all the posts of DFO are being held by ADCF or by some recently inducted IFS officer, State Arunachal Pradesh Forest Service cadre. So if they take,
facts remains that it should be manned by IFS.
they are saying in their affidavit, my lord. So you replace me by some IFS officer if you are saying taking that ground, my lord. So therefore, my lord, from record itself, even if I don't allege any malafide also, my lord. Malafide in law, my lord, malice in law is very clear. Firstly, trying to replace me by some one who is not from the same cadre and who has not yet born into the cadre also, my lord, and who has been there for 15 years. Secondly, my lord, by taking such ground that this is designated for IFS officer, my lord. Whereas in some other places, maximum places, my lord, this is the appointment is made to the ADCF officers, my lord. Therefore, my lord, this transfer posting order, my lord, it's arbitrary. And to my humble submission, my lord, this needs to be interfered. And tomorrow, if any IFS officer or any eligible officer, my lord, if I am replaced with them, I have no objection, my lord. That much, my lord. And subject to if something new material comes, I'll have some revision there.
Yes. Put it down.
We have admitted that the private respondent here in Sri Neeraj Tamuk
Is not eligible.
no, he's ACF entry grade who has been promoted on 25/3/2025. As per my affidavit also is on probation. We have not denied that. But that we are saying that we are following Arunachal Pradesh Forest Service Rules 2019. It doesn't debar any rank of ACF entry grade on probation period. But it doesn't debar to hold the post of the
Schedule 1C, this is supposed to be attached to by ADCF only, not the ACF.
Lordship.
DFO division, Pasigat division, forest division.
That I have.
So how can you make a statement?
Lordship.
Take a stand contrary to your own rules when you are following that?
Lordship.
Of course, it doesn't say that it should be manned by only that thing, but
yes,
it is shown to be ADCF as per the schedule. That's all.
In whole of we have said that only, Lordship. Nothing.
Yes, madam. This affidavit is by? Your affidavit is?
Lordship, by the respondent number 1 and 2.
Okay, 1 and 2. Yes.
And my lord, one small citation. That is at page, my lord, 58, my lord, in this petition itself, my lord.
I've seen it.
My lord.
Hibutama.
No, my lord. Moririba.
Based on Hibutama.
My lord. But then this similarly situated, my lord, ACF and ADCF, that is the similar case, my lord.
They refer this thing. Okay.
May I please, Your Lordship?
Yes.
In view of the government affidavit, citing the Gazette notification dated 9 March 2022, wherein the post of DFO is to be held by the IFS cadre, the petitioner is also not eligible to hold. But I would put it in this way, Lordship. In his reply also, he has said that there are so many other posts in which other people are being, other officers who are non-IFS are being posted. It shows only one thing, that there are a shortage of IFS officers probably. So therefore, these other officers are posted. Now, Lordship, the petitioner's case should be that my service conditions are being affected, that I'm posted to a place where I'm not to be posted. That is not the case here. He has been posted to a place where he's supposed to be posted. And it is not mentioned anywhere that the rule is a mandatory thing, that the government cannot have some freedom in the joints. Because to post an officer there or here, it is for the government to decide. If there is a shortage of posts, maybe they will send somebody who is who can be posted there, even if he is not ADCF. Probably that is why the government has done that, but that is for the government to say. Now, regarding, I have mentioned in para 13 of my affidavit in opposition that the place where he is posted is as DFO silviculture as per the impugned transfer order. It is not that his service conditions are affected. Simply saying that I have been replaced by a junior officer, how is he affected that way? The only thing that has to be is whether or not he is affected. Now he has relied on Moririba case. Your Lordship has, when this case was referred in another case, by a division bench, Your Lordship has held in para 19 to 24. This was also a case where the case of Moririba was also mentioned, also Hibutama and Nyapung Konya. The number of cases in which it was held that even in transfer cases, junior should not replace it should be an inter-cadre transfer. Lordship will see at paragraph 18 also, the case which he is referring to, Moririba. Then your Lordship has said at para 19. Perusal of the above judgments of the learned single benches of this court shows that the learned single benches have held it is not permissible to make interstate transfer between officers who are not similarly placed officers in the department. Having perused the judgments, we are of the view that it may be correct that normally it may not be permissible to make interstate transfer between officers who are not similarly placed officers in the department. However, there would not be a complete bar to transfer an officer serving on in charge or officiating or functional basis in higher posts unless it has caused prejudice and affect the service conditions of the officer who is sought to be transferred to a different place of posting with the same rank, status, and benefits depending on the administrative exigencies. It is true that the higher officer cannot be replaced by a junior officer who may not be competent to work in the said post. However, in the given circumstance, if the officer is competent, having the knowledge and experience with his
oblique her considerable length of service, in our view, there would not be a bar on such transfer and posting. In the present case, there is nothing to show on record that the junior officer who was allowed to serve in charge in the higher post for a considerable time cannot be allowed to serve as in charge of that post, considering the service experience of the junior officer, which may have gained in the course of service. Then your lordship may see para 22. We may refer to some of the settled principle of law on judicial review in the matters of transfer of government employees by Honorable Supreme Court. In the case of NK Singh versus Union of India, reported in so-and-so, the Honorable Supreme Court has held that the scope of judicial review in matters of transfer of a government servant to an equivalent post without any adverse consequence in the service, on the service or career prospect is very limited, being only grounds of mala fide and violation of any specific provision of law. So my contention is, Lordship, that it cannot be a case of the petitioner that when these rules are mandatory, so therefore the government cannot, under any circumstance, post any ACF in place of an ADCF. He has shown by his affidavit in reply also that if in fact it is a post to be held by an IFS officer, but other officers are being posted there. So it only goes to show that it is not a mandatory provision, because if it is so, then there might be a shortage of officers. So therefore, without anything further, it cannot be said that the transfer order is liable to be quashed, Lordship. So therefore, this writ petition, in my humble submission, does not have any merit. It may be dismissed, Lordship.
But madam, here is a case, there is a rule. The post has to be won by the, he cannot have an...
In Moririba case also, that was exactly the point, Lordship. Your Lordship has seen that, and the division bench of this Honorable Court has passed this order. After seeing the Moririba case, in which the same contention was made. Of course, the circumstances were different there. There was a case of frequent transfer. Also, in the other cases which they have referred, Nyapung Konya and Hibutama case, there were elements of political interference there. Not just non-intercader posting, but also political interference. If the rules are so rigid, then the government will not be able to post anyone, because there are shortage of officers. That is why non-IFS officers are also posted. This is, of course, for the government to clarify.
In the Moririba case, what was the action?
Page 58 onwards. Paragraph 7, actually, page 61. 3 so-and-so, counsel for the petitioner, part submitted by an order dated so-and-so. The respondent number 3 was promoted from the post of range forest officer RFO to ACF, and the said promotion was for a probation for 2 years, which is to be followed by a confirmation of service. He has reiterated that such confirmation would be done as per Rule 24, read with Rule 14 of the aforesaid rules of 2019. He has submitted that as on that issuance of impugned order dated so-and-so, respondent was still in the probation period as an ACF, which is otherwise also lower in grade to the post of DCF held by the petitioner. He further submitted that taking cognizance of such procedure and substitute. These are the fact, my lord.
Yes. Have you seen the judgment?
No, my lord.
Authored by this court. We have seen that this case matter also. Moririba's case.
Maybe, my lord, they are in the rules. Herein, it's very clear, my lord. Schedule, my lord, that is.
She said, what she has submitted that by considering this matter,
my lord.
this court has something, division bench has something different.
Well,
in the junior, there may not be absolute bar to post a junior replacing a senior. In the exigencies, it can be.
But in my lord, exigency, nothing has been.
Then you have to challenge the division bench. This Moririba, which you are relying,
my lord,
that has been placed in that case. Of course, the facts, this was different, but the observation and the findings of the division bench said, after considering all this, that it cannot be absolute bar that the person, a junior,
each authority, my lord,
be, huh?
There can be a difference in facts, my lord.
No, but then this, coming to this conclusion, that junior cannot be.
My lord. Maybe in that case, my lord, this service rules.
No.
It was,
It's okay. This is something different. It is regarding posting of executive engineer, assistant or executive engineer.
My lord.
But while dealing with in that case, that Moririba's case was also considered.
Maybe, my lord.
That is what she is saying.
Maybe, my lord. But
and thereafter considered, but then had held that division bench has held that there may not be absolute bar,
my lord,
to transfer a junior in given circumstances.
There may be, my lord.
Normally, it should not be.
My lord.
Should not be, junior should not be replaced. But that cannot be, there should not be absolute bar.
My lord, there may be.
After considering that case.
But then, my lord, if the facts and circumstances of that case is different.
No. Are you getting my point?
I'm getting, my lord. Because, my lord, applied this law to my case, my lord. At least the facts and circumstances of that case and my case should be similar.
See, what he specifically pointed out that in that case,
my lord,
the division bench,
my lord,
unfortunately authored by this court, after consideration of the law case judgment relied by you, here Moririba,
my lord,
has observed that there may not be bar to post a junior replacing a senior,
my lord,
in given facts and circumstances,
my lord,
right?
My lord,
Therefore, that was not agreed with.
my lord.
So far as this, forget about, there are so many other cases,
My lord,
including this Hibutama, Nyapung, what is Hibutama, Nyapung Konya, and all this. Page 69, which has been referred in this thing.
My lord.
In Moririba's case. Although in Moririba's case, same submission.
My lord. Facts are different, seems, my lord. Here in this case, my lord, in charge.
Who says that facts are not different?
My lord.
Who said facts are obviously different?
Therefore, my lord, I am saying.
But then while coming to that finding,
my lord,
observation,
my lord,
this Moririba's case was also considered.
My lord. That was considered, my lord. But then to apply this authority in my case, my lord, I am saying, my lord, my humble submission, facts are different, my lord. Therefore, to apply that particular law, if the facts are different in a case.
The issue was whether a junior
My
can
lord.
be replaced the senior.
My lord, in this case, in charge, my lord. But in our case, directly you have given the force of DFO, my lord, violating the statutory rules, my lord.
But problem is that which was held to be not illegal in the Mori Ribas case, that has been considered and the conclusion has been arrived at.
May I read it again, my lord? The same judgment by Honorable Division Bench, para 19. Having perused the judgments, we are of the view that it may be correct that normally it may not be permissible to make interstate transfer between officers who are not similarly placed officers in the department. However, there would not be a complete bar to transfer an officer serving on in charge, my lord, officiating, my lord, or functional basis in a higher post, unless it has caused any prejudice and affect the service condition of the officer who is sought to be transferred to a different place of posting with same rank, status, and benefits depending on administrative exigency. To issue, my lord, there should be administrative exigency that is lacking in this case.
How?
We have to rely on the government.
No, it should not be detrimental prejudice to you. By posting you and bringing him should not cause any prejudice to you. What prejudice has suffered?
Because
what prejudice you have suffered by transferring you as a DFO sericulture?
My lord.
Same rank.
That is same rank, my lord. That is it.
You have not been transferred to the post which is to be held by ACF or the lower the rank.
Correct,
No
my lord.
prejudice.
Correct, my lord. That is correct, my lord.
Only division, forest division and the, sericulture. Same post, DFO.
That is correct, my lord. But an only issue, my lord understood. I am saying, my lord, if
Where is the disposal of your representation?
that is at page, my lord.
Disposal order.
Page 52, my lord.
And have you read the, except for one conspirator and taking into account the respondent was not even not even in the cadre petition and post where the petition was transferred. by the order is not in the cadre when the respondent number 3 is performing namely so and so. So this code is to consider due the MP is answered in there. That rule and other thing has not been discussed here.
Muririba case, my lord.
Only because you are ACF. I mean, the other one was ACF. Yes, page 50.
Page
52.
My lord.
Lordship, in fifth paragraph here, we have said that due to shortage of cadre officers in the state, that is 19 cadre officers presently in position against a sanctioned strength of 21. Temporary arrangements has been made in accordance with Rule 9 and 7B of the Indian Forest Service Rules 1966 in the interest of public service and administrative continuity. And that we have, Lordship, stated in our affidavit also.
And my lord, the other requirement, my lord, of the Honorable Division Bench order, my lord. It is true that the higher officer cannot be replaced by a junior officer who may not be competent to work in the said post. However, in the given circumstances, my lord, if the officer is competent, having the knowledge and experience with her considerable length of service, in our view, there would not be bar on such transfer and posting, my lord.
Yes. That's all.
That's
Anything else?
While disposing of representation, my lord, that cadre strength of IFS that was not given as ground. But while filing affidavit by the government, respondent number 1 and 2, they have raised that issue.
Saying what?
Saying that since that Pasighar depot is designated cadre post for IFS, so you are also not eligible. But then kindly come to page my affidavit in reply, my lord.
Not eligible in the sense that exigencies, even if it is designated and the shortage of IFS officer, anyone could be placed.
No, ADCF, my lord. Not ADCF. Arunachal Pradesh Forest Service. They have mentioned in paragraph.
Para 5 of the order.
No, my lord. In their affidavit, my lord, one is specific.
I read it.
Page 77. In my case, page 77. In their affidavit, page 77. Kindly come to last paragraph of page 76, my lord.
$76.
76.
Affidavit filed by counsel.
1 and 2.
1 and 2.
1 and 2 starts from page 79.
Yes, Lordship,
Para
84, 84, para 8, page 84. In my
Para 8 is page 83.
83 and
Yes.
relevant is 84. 84.
In my pagination, it's 76.
It's wrong.
Oh.
They didn't change it.
Being a matter of record, it is agreed that the respondent number 3 so was promoted to the ACF grade from the range officer group B, registered on 25/3/2025, and is on probation. But there is no statutory provision in Arunachal Pradesh Service Rules 2007 which debar a PPS officer in the rank of ACF entry grade, who is on probationary period from being transferred and posted to hold a charge of the post of DFO, Pasigat Forest Division. Now here it is contradictory, my lord. Service rules schedule, it says different, my lord. Forest Division being a cadre division, the post of DFO is to be held by a cadre officer, Pasigat Forest Division being a cadre division, the post of DFO is to be held by a cadre officer, IFS officer. However, as per Rule 9A of Indian Forest Service Cadre Rule 1966, in case of non-ability of sufficient cadre officer, the state government being the competent authority may consider posting of non-cadre officer, that is, Arunachal Pradesh Forest Service officers for time being. Herein, my lord, I pause for a moment, my lord. Because, my lord, repeatedly I have taken that ground, since this respondent number 3 is on probation, my lord. He has, my lord, not born into the entry cadre itself, my lord. The present strength of cadre officers IFS in the state is 18 against the sanctioned strength of 21, and out of 18 present cadre officer, 1 officer is on state deputation. Now they have annexed, my lord. Kindly come to page 92, annexure B in my affidavit in opposition. आपका में कितना है?
98. This cannot be 98.
Annexure B.
Your affidavit starts from page 111, 172.
Is 100, Lordship. Annexure B is 100. Is page 100.
Okay.
Annexure B.
B.
Affidavit in reply.
Affidavit in opposition, my lord.
Yes, what do you want to say?
Page.
Yes. Pages doesn't tally. What do you want to show?
My lord, they have shown the territorial jurisdiction designated for IFS.
Page 98.
Yes.
Annexure B.
Annexure B, my lord.
Yes.
Page 100, Annexure B is.
In my case, page 94, my lord. Annexure B. It starts from Arunachal Pradesh, Goa, Mizoram, and Union Territories.
Lordship, page 102. 102.
It's a part of this Gazette of India. It's 100, Annexure B. Page 102, yes.
Yes, my lord.
Why your pagination in your brief is different?
I don't know, my lord. We have been served like that.
Yes.
Now, my lord, Arunachal Pradesh, Goa, Mizoram, and Union Territories, my lord. Post under government of Arunachal Pradesh is 40, my lord. Now, kindly come down to 1, 2, 3, 4. From bottom on 4th. Deputy Conservator of Forests Territorial. This they are saying it is this places are designated for IFS, namely Namsai, Roing, Jerampur, Diomali, Bandardua, Teju, Pasigat, Bomdila, Along, Hapoli, and Tawang, my lord. Now kindly
DCF.
D-shape, my lord.
IFS.
IFS D-shape, my lord.
You are not IFS.
No, my lord. I'm my lord. Now, in my affidavit in reply, my lord, kindly come to page 177, my lord.
What do you want to say?
My lord, I want to say that
Although it may be designated for IFS, but then ADCF are being posted as DFO.
my lord, in almost all the places, my lord.
So,
And my
you are
lord,
not disputing that this is designated.
not disputing, my lord. So in my single case, my
So
lord,
if this is a designated place, a designated posting for IFS,
my lord,
you are equally not entitled if you are admitting that.
that is what they are saying, my lord.
So you are.
But in this stand, they have not taken in the while disposing of the
They say that shortage of the IFS. What does it mean? They have not said so. No, they cannot say also, right? Because they have not posted IFS.
My lord.
Now they say that though it may be, we may take that way. It may be designated.
My lord.
Place of place for or territory for the
IFS, my lord.
IFS. Anyone can be below the IFS or whatever DCF can be posted because there is a shortage of IFS officers.
But then
IFS officer.
But then, my lord, not ACF, my lord. Not ACF, my lord.
Why?
Because for ACF, my lord, rules schedule says for them there are some different places.
No, if it is IFS, I see IFS also, they can be designated as ADCF.
No, my lord. IFS, my lord, Indian Forest Service, my lord. These are, no. These are designated area, my lord. The places which I have mentioned.
IFS means which post?
DCF, my lord.
That's why I'm asking.
DCF. But then respondent number 3, ACF, my lord. And for
Forget about him for a time being.
My lord.
We know that they are not entitled. Now on you, whether you are also entitled to be posted there. Just because you have been posted,
my lord,
unless you show that you have a right to continue,
my lord,
a right to be posted. When you admitted that this is a designated place for area or the territory for the IFS
my lord,
officers who would be in the rank of DCF.
ADCF. ADCF, my lord. My lord.
IFS means what?
DCF.
ADCF.
DCF, my lord.
That's what I'm saying.
My lord.
Their IFS designated area is place is IFS for IFS only.
My lord.
Who would be DCF?
My
the
lord.
post would be DCF.
My lord.
Right. You are ADCF.
My lord.
So what is your right to continue there?
My lord.
You will take it. There may be aberration that at least the IPS should have been posted. But then illegality is difficult.
My lord, if
there may be heart burning because you are senior, you are above him. You are in the higher cadre.
My lord, if such action is allowed, my lord,
We'll
tomorrow,
say both of you are not eligible. Let there be IPS, DCF. Okay.
my
What
lord,
benefit you will get in that case?
in that case, at least, my lord, law, my lord, will settle that.
To satisfy your ego only.
No, not ego, my lord. This will be kind of thing if
Because
such.
you will not be getting relief. More so you are not there.
Now
You have
also, my
already
lord, I am saying
completed
if some,
3 years.
if some IPS,
And you have not been posted to a lower rank
that is correct, my lord.
or lower, the post, the place where the posts are being held by the lower cadre or
My lord.
HCF.
That is correct, my lord.
Only your grievance is that why, although you may not have a right to continue,
My
but
lord.
then why lower grade, officers should be lower in rank,
My lord.
officers should be posted by relieving you.
My lord. And then
What
in violation of schedule C and D, my lord, of rules.
let's see again. Let us see. C and D.
Page 30. Page 40, my lord.
Post under additional deputy conservator of forest. This is ADCF.
ADCF, my lord.
As attached officer in various forest division.
My lord. And serial number 3 is Pasigat, my lord. And in my affidavit, my lord, in reply, what I tried to show this honorable court is all those 11 places, my lord.
What does D is post under assistant conservator of forest.
C is the additional deputy conservator of forest. As attached officer, they can be posted in that forest division.
It doesn't say also that you will be posted as DFO.
That is correct, my lord.
Then,
but then because of this, my lord, rest, my lord, rest places, my lord, it is being held by ADCF, my lord. And kindly come to D, my lord.
So there might have been other ADCF must have been allowed, but it's not exactly in terms of the rules. This is
D, my lord.
Rule 4.1. Let us see rule 4.1. Strength of the service.
My lord.
The authorized permanent strength of the service and the post included.
In schedule 1, my lord.
This number of posts in senior grade of the service shall be 30% of daily post. Includes deputation reserve, training reserve, and leave reserve.
The schedule is part of rule, my lord.
No, this is a case where you are not agreed by your transfer. You are agreed by the transfer of the respondent number 3.
Correct. In violation of.
What does it make a difference? Unless it causes any prejudice to you.
That is there, my lord. But then this type of action, if my lord not interfered, my lord.
No, they say if you cannot show any prejudice, you have to agree by your agree because something has caused hardship or whatever deprived to you,
Deprivation, my lord, in terms of service.
then infringes your right. You have been transferred in the same post, maybe in a different place.
My lord. That is there, my lord.
So you admit that this is, you are agreed by the transfer of the petition respondent number 3, not by your transfer. Is not it?
My lord.
How can then we consider? If you are not agreed by your own transfer.
On transfer, my lord, definitely
We'll
will be
first
there.
consider
If suppose,
what any prejudice is caused to you.
in terms of, my lord, service, whatever, my lord.
See, for example, if it is, not for example, if it is a post to be manned by IFS officer, admittedly you are not an IFS officer.
My lord.
Right? The post may be shown to be attached. Your post may be shown to be attached in a particular division.
My lord.
It doesn't mean that a rule is violated. Designated the division to be manned by the IFS officer is not dispute.
Not dispute, my lord.
You are not disputing it.
Not disputing, my lord.
Once it is done, maybe you may be attached there also, even if IFS officer is there. Right? Rules only, schedule to rules only shows that your post, the ADCF, may be attached to it.
My lord.
But if you are not disputing that it is a designated post for,
my lord,
it doesn't make a difference. There's no violation as such.
My lord, in that case, my lord, therefore, my lord, in my affidavit, I have shown all those places, my lord.
Doesn't mean, see, that is amounts to claiming negative equality.
Negative equality, it is there, my lord.
Not allowed by the rules or contrary rules. If somebody is allowed, you cannot claim penalty or similar treatment from that action. So as you know, Article 14 there's no concept of
negative equality
or postulate any negative equality under Article 14.
That is there, my lord. But then, my lord, if someone are placed there, that those also are designated for IFS. Only in my question, if we can choose, my lord, they say no, you cannot be there.
In a public, in a service jurisprudence or in a public service matter, first you have to be agreed with some actions which affects to you, or you have to show some infringement of your right. Otherwise, all this transparent posting, it's a domain of the authorities.
That is there, my lord. But then in such a manner, if this is encouraged, my lord, therefore kindly, my lord.
So unless you show that you have an indefeasible right to continue,
but if someone is
while transferring you, forget about respondent number 3. They may bring someone, they may appoint, allows to somebody. It may be illegal, but then unless it affects you,
my lord.
How does it affect you?
My lord,
that too you have completed normal tenure.
My lord.
No issue, no problem, no dispute.
No
so what I'm trying to indicate is that unless you show any prejudice to you, unless you show any violation or infringement of right in transferring you, it's difficult to consider. Just because some junior has been placed in your thing without causing any prejudice to you, because you have been transferred to DFO.
Even
DFO only.
Even if that is in violation of service rule, my lord.
I don't see any violation. Anyway. But madam, you are also not equally entitled. Is not it? At least you are not even entitled to, forget about the DFO. Your post is to be attached in particular areas.
Yes.
At least in that context, he may have the point, although he may not right to continue there.
In his affidavit and reply itself,
He has also mentioned one post in Bongdila, in which one ACF is holding the post of DFO.
He's saying.
Yes.
No, that is after completion of probation, my lord.
It doesn't make a difference. Probation, I'm not interested.
From what I'm seeing, it
Is there anything to show that until the probation cannot be transferred? Until you complete the probation.
Cannot be transferred.
Probation is for what?
My lord. That I understand, my lord.
To test the suitability.
My lord.
Suppose a person is posted in some other place. That could be one of the testing his or her suitability.
But then confirmation rule 24, it is very clear.
There is a question of confirmation. It's a posting only.
My lord.
It's not that before the requirement of posting a person in a particular place is to be a confirmed employee. Is it so?
Where will the person be posted if he's on probation? Will he be in training for it?
Probation is only for
My lord, confirmation rule says
training and probation are two different, completely two different concepts. Probation, my understanding,
my lord,
is pure and simple, just for suitability.
Suitability, my lord.
Training may be a part of that.
And 24 rules is clear, my lord. For confirmation, there has to be a board. Only after confirmation, my lord.
Where is only after confirmation? Where will be? Is there any provision for posting?
Posting, it is not there, my lord.
Then, where on posting?
These are all connected, my lord, to my understanding.
From what I have seen, my lord,
Recently, my lord,
as per his own affidavit in reply, 11 posts of DFO in different divisions. Some ADCF are holding, some ACF, some
ACF only one, madam.
DCF. So it only goes on to show that what the government is saying is true, that there are no IFS officers. So therefore, the cadre strength is 21.
The government is saying only one IFS officer is on deputation.
But they are also not able to show
Yes.
why the petitioner has to be posted. There is a DFO sericulture. What is the administrative exigence? You are saying only that it is public interest, saying it's become, I mean.
It appears to be a normal transfer because the petitioner is not the only person to be transferred.
That's absent.
Yes.
Anyway, so that's all. Mr. Ketama, London Council for the petitioner. And also had MS G. London Additional Senior Government Advocate for state respondent number
1 and 2, Lordship.
1 and 2. And MS N. Dangan, London Council for respondent number 3. The challenge made in this petition is to the order of transfer dated. Year is also not mentioned. 16 July 2025. Passed by the PCCF and HOFF within bracket E, F, and CC, bracket close. Government of Arunachal Pradesh, page 47. Whereby as many as 15 state forest officers, including the petitioner and the respondent number 3, have been transferred and posted in the different places of posting, and also the subsequent order passed by the subsequent order dated 4/9/2025.
4/9.
5/9.
Just a minute, my lord.
5/9,
5/9, my lord.
5/9.
Disposal of
2025. by PCCF and so and so, same HOFF so and so, by which the representation of the petitioner for retention him at Pasigat has been rejected.
My lord. And directed me to join the new place.
Okay. And directed the petitioners to report to his new place of posting at DFO. Silviculture division.
Silviculture.
Silviculture division. Itano. I'll pass the order in the chamber. We'll continue there. Huh? Let us see that most unlikely. Call.
Yes, I have called.